That means
both the test based. Higher dismiss.
Wait, please, your lordship.
Yes.
Let the matter be listed for orders, my lord. This is a case of contempt, my lord.
When?
Petitioner, all the petitioner did not get their salaries, my lord, at that since the provincialization of the school.
When do you want?
On 28.
Yeah.
2020 or 27, my lord, 27. Because similarly situated cases fixed on 27. বন্ধ নেকি?
May I please, your lordship? I filed for review your lordship order, my lord. I have filed the IA on 19th of last month, my lord. The listing, I'm paying for listing of this matter.
When do you want?
On the day after tomorrow, my lord.
Yeah.
Obliged, my lord.
My lord, this is a motion matter, my lord. It was filed before summer vacation. And
Not that.
it may be listed on
When do you want?
Wednesday, my lord,
When-
28th.
Okay.
My lord, I have prayer for making it, my lord, moving an urgent motion today, my lord, if possible.
Today?
Today, if possible. Or tomorrow, my lord. Tomorrow, my lord. Deep level.
Please, your lordship. I beg to mention for item number 33, your lordship. I am to file affidavit in this case, your lordship. So 1 week time may be granted for filing.
I'm appearing, your lordship, on behalf of secondary education.
I have
Item
taken
number 33.
33. I have taken the consent of other side, your lordship.
My lord, I am appearing for the petitioner. My lord, a short time may be given. I am appearing for the petition.
The secretary learned advocates of both the parties will settle is the matter.
After 1 week, my lord, they have sought for 1 week's
After
time.
1 week.
For 1 week.
29.
Obliged, my lord.
May I please, your lordship? I beg to mention item number 21, your lordship, for motion. The matter may be adjourned for the day and may fixed on Friday next, your lordship.
21.
Lordship. The 22nd may become,
On the fair being made by Mr.
as to say.
Learned contempt for the petitioner. This your time is not there.
Yes, your lordship, I won't be able to ask early, your lordship, due to some unavoidable circumstances.
Learned
If-
contempt. Appearing on behalf of Mr. S. Ali learned Friday.
Lordship.
May I
Lordship.
please, I beg to mention for listing 2 matters, my lord, for admission.
When?
This week, my lord.
This week.
22nd.
Going for listing of an IA for orders, lordship.
22nd and
After-
27th.
Day after
Okay.
tomorrow, if possible, day after tomorrow, lordship.
After-
Obliged.
Hey, please, your lordship, I beg to mention for listing of a fresh petition, lordship, there is an urgency, lordship. It is also
What petition?
fresh petition, lordship,
Madam?
fresh petition, lordship. The lordship, this
This petition.
tomorrow, lordship.
My lord, I beg to mention for listing of 1 IA, my lord, on the 21st. Yes, ma'am.
May I please, your lordship? Lordship, there is a ISC bill for listing on Friday.
ISA. ISA will you go to the court number 8.
Already registered. Contact
ISA. Okay. When do you want?
22nd.
22nd.
May I please, your lordship, therefore listing, lordship, on additional matter, lordship, on 20, lordship. Matter regarding, lordship, provincialization of
On
service.
20.
20, lordship.
May I please, your lordship? Read petition. I'm praying for listings.
When?
For orders.
When?
When your lordship? Oblige, your lord. May I please, Your Lordship?
Hmm.
Lordship, this contempt petition is filed for non-compliance of the order dated 21/3/25. Lordship. Order is, Lordship, in page number, Lordship, page number 14 in Extra 1, Lordship. Lordship, operative portion is, Lordship, in page number 18, Lordship. Para 14 and 15, Lordship. Page number 18, para 14 and 15.
Let's go ahead.
Yes,
First,
Lordship.
miss, your good name, please.
Miss A. Begum.
Miss A. Begum, learned counsel for the applicant. This application under section 12 of the Contempt of Act 1971 reduced article 215 of the yeah. Is referred by the applicant for initiation of contempt proceeding against the contempt of for disobedient and deliberate non-compliance of the judgment and order dated 21/8/2025 was which is court in WBC number 6585 of the where is the petition and the lesson record and the order dated 21/3/2025 was in WBC number 6585. And notice be issued to the response to the contempt returnable in for its be taken by registered post with ATN also by the post. List subtract for each.
Lordship, kindly date me fix, Lordship. October,
Before the
before vacation, Lordship. Lordship. Bless you.
May I please, madam?
yeah.
This is a contempt petition filed against non-compliance of the order dated 12/6/25, which is at page 12. And the operative portion is at page 24, paragraph 33 at the bottom, my lord. While proceeding to issue fresh order, Director Secondary Education Assam shall construe the MA degree obtained by the petitioner in writ petition so and so to be a valid degree, and also construe the petitioner in writ petition so and so to have completed minimum required lengths of 17 years of service as a graduate teacher in higher secondary school of the state, and thereafter passed appropriate orders in the matter. Such order be passed within a period of 1 month from the date of receipt of the certified copy of this order. And thereafter, my lord, the petitioner has filed this certified copy at Annexure B, 26 page, my lord.
26 of
Page number 26, Annexure B, my lord.
what did you file the certificate?
So, certified copy was filed before the director as per orders of this honorable court, my lord, on
When did you file?
my lord,
When did you file?
on 23/6/25, my. And thereafter, a reminder was also given on 18/7/25, but till date, no compliance has been made.
Or your
M. Khatanyan.
article 215 the paper by date 12/6/25 12/6
No, sir.
Hello, this is contempt petition, my lord. Honorable court's order is at page 9, my lord. And operative portion at page 14, my lord, paragraph 16. Accordingly, this writ petition is disposed of with a direction to the petitioner to submit a representation before the Director of Education BTC annexing all the relevant documents within 10 days from today. On receipt of such representation, Director of Education BTC, respondent number 5 shall consider the case of the petitioner as per policy decision as referred to above in terms of the direction contained in the order dated 6/2/2015 passed in WA number 182 of 2013. It goes without saying that if the case of the petitioner is covered by the policy decision as referred to above, Director of Education BTC shall pass an appropriate order reinstating the petitioner by regularizing the service of the petitioner. The above exercise shall be completed within a period of 3 months from the date of receipt of the certified copy of this order. Thereafter, my lord, petitioner submitted the certified copy along with representation on 16/2/2024. But till then, no compliance. Hello, the contempt petition, my lord. Honorable court's order is at page 10, my lord. And operative portion is at page 13, my lord. Paragraph 10. In view of above, petitioners hereby required to submit individually detailed representation before the Director of Education BTC along with a certified copy of its order enclosing therein all requisite particulars with regard to their appointment, termination, etc. on or before 15/2/2024. And my lord, at paragraph 11, my lord, in the event any such representations are submitted by the petitioner individually, the same shall be given its due consideration under the policy in place as well as under the direction contained in the judgment and order dated 6/2/2015 passed by the division bench of this court in writ appeal number 182 of 2013. If on such consideration and after making due verifications, it is found that the cases of the petitioners are covered under the policy in place as well as the direction contained in the judgment and order dated 6/2/2015, Director of Education BTC shall proceed to issue orders towards reinstating the petitioners in their respective services, and thereafter all shall regularize their service. And thereafter, my lord, they submitted the representation along with the certified copy on 2/2/2024. Until that, no compliance with the order of this honorable. This matter also, my lord, non-compliance of the order dated 8/1/2024 passed in WPC 6618/2021. So the operative portion is at 12, my lord. Paragraph 5. Publish.
My lord, it's a contempt petition. It's the non-compliance of the order dated 9/1/2025. Notice may be issued.
Your good name, please.
Yes, sir. Yeah.
Yes, yeah, sorry. Subject. Well, by the one the product not for this subject for
Obliged.
Contempt petition, my lord, against judgment and order dated, my lord, 8/1/2025, my lord. Operative portion, my lord, is 41, my lord. My lord, 34 and 35, my lord. 40 last married. Page 40 of para 34, my lord. Married, my lord. For the foregoing reasons and view of the Duludevi case supra, the impugn order of termination dated 18/5/92 is not sustainable as the respondent authority have failed to place on record so as to show that proper procedure has been followed and consequently the termination order was served to the petitioner as held by the Supreme Court. Even if the order is passed and merely kept in the file, it would not be treated to be an order of termination service, nor shall the said order be deemed to have been communicated. Accordingly, termination order dated 18/5/92 is set aside and quashed. It is provided that the petitioner shall be entitled all the benefits as assistant teacher as they have been allowed to continue service till filing of this petition, and they shall be treated as a regular assistant teacher for all purposes. Final, and final representation pay annexer to page 42 and praying for last mile. Therefore, we pray before good self to pay regular salary up to 2007 till death and retirement from service, and those who are not retired shall be paid regular salary till their date of retirement, and also to be allowed to ask all service benefit as well as regular pension. Hello. Except my
sir for a with or dated 8/1/5 of 8 with it of there is one concept.
is one con and the second is also same, my lord. Read petition is different, but orders first and regular. Common judgment, man.
Okay.
Only read petition is different. Man. Much.
Password for time.
Typing.
Ending, Lord.
time being.
Well, in this case, my last occasion, I was directed to bring instruction. Mal. I have not received mal. Some more time granted. Mal.
Yes, any objection? Or that,
NM Das.
then that, for a
Elementary Education Department.
the Bora submitted by order dated 15 directed and that
10 days, mal.
after
Obliged, mal.
Appearing for respondent too. I am appearing for respondent.
Lordship, before that, Lordship, this case is conducted by S. Das Lordship. S. Das is conducting this case, Lordship. So in the morning, was maternal and his expired, Lordship. Only one day, accommodation, Lordship.
one day.
Otherwise, my lord, my service will be co, my lord. Because today is the last date, my lord. What happened, my lord, in this case, my lord,
When
because petitioner was appointed. Today is the last date, my lord. Whereas, my lord, earlier occasion, my lord, this order was passed on 22nd, my lord. Actually, what happened, my lord, the petitioner is working under the provisions of GF. And this is the first extension, this is the first appointment. As per the office memorandum, my lord, the one TF appointee has the right to get the two another extension, 4 months and 4 months.
go to the record, which is
Lordship. Lordship, his come today, Lordship, estimation for.
He is also the standing counsel, my lord.
you please go through the record.
Lordship, file with, no, I have to get second file. I have file not file within Simanto Lordship.
Pardon?
File with as Das Lordship. I go
No,
to.
no, you can go through this file.
But
We will take it away to
Obliged, your lordship.
no,
My pleasure, Lordship. Lordship, the petitioner before your Lordship is a postgraduate student in Silchar Medical College. Lordship, the issue is, Lordship, he has secured admission in the year 2023 in MD Psychiatry. Now, Lordship, all of a sudden, on 6/8/2025, that is at page 96, page 96, Lordship. Page 96, Lordship, this order of 6/8/2025. If I may read it, Lordship, as per the direction of Director of Medical Education by letter number so and so, admission of the following students of Silchar Medical College and Hospital, Silchar, admitted during the session 2023 are hereby cancelled with immediate effect. Now, Lordship, the seats which were secured by me in the year 2023 are being cancelled in 2025 without assigning any reasons. This letter does not reflect any reason for such cancellation after 2 years. And these 2 years, we have been all along attending the classes and other
whether
Lord.
for passing the order and
no notice was given, Lordship. No notice was given before passing this order. We have made a categorical statement to that effect that there was no prior opportunity given to us. And Lordship, now after passing of this order, we have been given to understand that since NOC was not obtained, therefore this order has been passed. Now, Lordship, your Lordship will find we had applied for NOC on 24/7/2023 before joining the course. For 2 years, the authorities sat over the matter.
from where you came to know that because of absence of
Lordship, upon visiting the office as to the what is the reason, that was the reason told verbally. We do not know whether that is the actual reason or not. Now, but this impugned order does not reflect any reason as to why this has been cancelled. Nor,
My lord, I have to obtain the instruction, my lord. Your lordship may take it up day after tomorrow. I will obtain the initial instruction.
Lordship, the only difficulty is after
Till the there the stay of this order.
My lord, this order is of 6/8/2025. 6/8, my lord. Only 2 days, my lord.
Lordship, because we are
Or
now
tomorrow also, my lord.
now we are
Or
deprived.
after some time, my lord. After 10-15 minutes, I will obtain the initial inspection. I will
Okay,
also.
2 o'clock.
Not before that, my lord. You can take, my
We
lord.
will try.
Yes, my lord.
We will try.
Yes, ma'am. Or, my lord, if I cannot contact, so day after tomorrow, my lord.
No, no.
Lordship, the only thing is
But tomorrow,
tomorrow, because they are not being allowed to attend their
Tomorrow,
classes
sir.
because of this order. After 2 years, this is
tomorrow, my lord.
Art, Mr.
A Chakraborty.
Chakraborty, order. Order. Mr. Bora, one day time of the after 2.
Lordship, only till then, because there is also a direction to vacate the hostel with immediate effect. That may not be at least pressed upon by the authority.
Tomorrow, in 1 day, no coercive action will be taken against them.
You from your
Yeah, I will ask the principal, my
not
lord.
to make it then.
Yes, my lord. I will talk to the principal, my lord, tomorrow.
Oblige.
16 and 17 are same, my lord.
Similar, Lordship.
16 and 17, not 15, my lord.
Lordship, for those also may be taken up.
Yes, these are Lordship. Second round of litigation, ma'am. Earlier petitioners came before his honorable court as the principal in charge, the inspector of school refused to provide any information as to why his salary in a particular month is deducted, my lord. Thereafter, only after filing an affidavit by the respondent authority, we have came to know due to an excess CL, his salary was deducted. But my lord, in fact, my lord, petitioner has not taken and applied for any excess CL which is beyond the acceptable limit of casual leave, my lord. Thereafter, my lord, the honorable court has passed an order, my lord. They were remanded the case of the petitioner before the Director of Secondary Education. The order of the honorable court is at page 89. Relevant portion is at page 92, my lord. Para 6. Here it is, my lord. After hearing learned counsel for the parties and on consideration of the materials available on record, what is discernible in the present writ petition is that similarly situated teachers who had availed access casual leave were adjusted against their earned leave by the inspector of school CDC Silser. Further, as the petitioner denied that he has not taken any casual leave for the year 2022, the same being a disputed question of fact, this court is unable to enter into the same exercising jurisdiction under Article 226 of the Constitution of India. Accordingly, the matter is remanded to the Director of Secondary Education, respond number 2, to have a verification as to whether the petitioner had availed any casual leave for the year 2022 by calling for the attendance register of Banskani so-and-so school for the year 2022. The respond number 2 shall also hear the petitioner in person in the presence of the principal of so-and-so school as well as the concerned inspector of school, and thereafter pass appropriate orders in accordance with law within a period of 2 months from the date of the receipt of a copy of the order of this honorable court. Thereafter, my lord, hearing held on, my lord, 26th of November, my lord, and impugn order has passed on, my lord, 17th March 2025. It is at page 29, madam.
It's number 20.
129. 129.
Annexure 20.
Annexure 20.
Findings has been, your lordship, elaborately illustrated,
my
your
lord.
lordship.
But in the perused column, my lord, there is no mention about the submission, any written statement. This is submitted by the petitioner on the date of hearing. At this stage, my lord, notice may.
Your lordship, I have objection, your lordship. First, your lordship,
What
taking, your lordship,
Let
is
office go, you file your
already matter has been heard in length, your lordship. Thereafter, order has been passed, and after that, your lordship, hearing was conducted, and findings has already been placed, your lordship. And this is, your lordship, elaborated, your lordship stated facts, your lordship, where his CL has not been considered because all total yearly it was 15 days, and he was availed more than availed 23 days leave in the academic year of 2022, which is more than 12 days, your lordship. That's why his CL has not been considered. And it was, your lordship, clear,
what is the profit?
your lordship, moreover, the FR 17,
If author, what is the profit? If somebody avail CL beyond the limit, then what is the procedure? No, no. Madam, your claim
ঠিক আছে,
are
হয়ে গেল না তো?
by by direct. Second, where the direct that's the of that of the access period of present that that take period that separate purpose started by that take the matter after or Madam, you are appearing for
I'm appearing for 1, 2, and 3.
what purpose or how
I'm deeply obliged.
May I please, Your Lord?
Yes.
Lord, the petitioner before your lordship is the IC Headmaster of Malakura ME School, your lordship. Your lordship may kindly peruse the impugn order, your lord.
It's what?
Page number 35. The petitioner is IC Headmaster since the year 2022. By this impugn order, the petitioner has been released from the IC Headmaster of the school. And one respondent number 8 is allowed to act as IC Headmaster, who is junior to the petitioner. Page 35.
You have not been appointed as regular headmaster.
My lord.
What wrong with this order?
My lord, it- not regular headmaster, IC headmaster.
Yeah.
But without giving an opportunity of hearing to the petitioner, this order has been passed, your lord. He has been
What
Sorry.
is the appointment order? As insert headmaster?
Yes, my lord, that is at page 22, your lord.
20?
22. Page 22. Abdul Rahim Sarkar. This is the petition, your lord.
within bracket tutor, assistant teacher of Malakoya Milon ME School is hereby temporarily allowed to draw and disburse the monthly salary of teaching and non-teaching staff of and other financial works of the school as IC headmaster in addition to his own normal duties with effect from 9/6/22 to 3/8/22 or till the regular headmaster is posted, whichever is earlier. As the IC head,
Now your successor is a regular headmaster.
my lord.
Now regular headmaster has been appointed.
No, my lord. He is also IC headmaster.
Yes.
My lord, may peruse page 7 of the petition, my lord.
Page 7.
7, my his statement, my lord. My lord, that by an order dated 5/2/2021, the Director of the Elementary Education Assam has provincialized the service of the petitioner, has been provincialized as tutor, my lord. And tutor, my lord, tutor cannot hold the charge of my lord, headmaster or principal. My lord, may peruse 105 of this book, my lord.
105.
My lord, you, my lord, provided, my lord, that a tutor
Not be eligible.
my lord shall not be eligible to hold the post of professor, principal, vice principal, headmaster, assistant headmaster, superintendent, assistant superintendent, as the case may be in educational institution provincialized under this act, my lord. There is nothing wrong, my lord. And other person, my lord, he has, if your lordship peruse, my lord, page 24, my lord. The person is, my lord, appointed as assistant teacher, my lord. Page 24, my lord, from the bottom, my lord, 4 line, my lord. My lord.
It's the
My my lord.
Before issuing the impung order, my lord, one opportunity of hearing to the petitioner was given him.
How prejudice the
And he is not appointed as regular headmaster, your lord. He is also IC headmaster.
There is no bar, my lord, because he is, my lord, not appointed as tutor, my lord. The petitioner is the tutor, my lord. The other person is assistant teacher, my lord.
The petitioner before your lordship is a BA DLED, having requisite qualification to hold the charge of
It is provision of the act.
my lord. But the definition of tutor, my lord.
Yes.
Page 105, my lord.
Yes.
Page 105. Close Q. Your lord. Tutor means and includes teacher, assistant teacher, classical.
The proviso.
My lord. That is
Provided that
my lord. Teacher shall not be eligible to hold the post of professor, principal, vice principal, headmaster, assistant headmaster, superintendent. It says, my lord, notice may be issued, my lord.
what is your case? As per law, you are not entitled to the
But against this person, my lord, that's number 8. There are several complaints from the school managing committee, your lord.
we are not supposed to adjudicate that the complaint is there or not again. Petition dismiss.
My lord, on some other maybe take,
Oh.
maybe take.
Lordship. The issue herein is also similar to item 14. Learned friend had told that he had received the instructions. Similar, they had joined in 2023 batch, applied for NOC. There was no communication thereafter, no response. Suddenly now it has been cancelled.
My lord, I have received the instruction, my lord. Actually, my lord, the order has been passed by the DME, Director of Medical Education, on the basis of a instruction from the Health and Family Welfare Department. And before passing of the order, my lord, no notice was issued to the petitioners, my lord. So, your lordship may issue notice, I will file a affidavit, my lord.
But this order is required to be stayed and I should be allowed to continue my classes because 2 years suddenly my classes have been stopped. Because notice, NOC was applied for in 2020.
Pardon, sir?
Hey, Chakraborty.
Turn it to the petition and also pardon, sir. Order, pardon. Petition, order dated 8/5. Annexer A 50, whereby the petition number impugned order is at page number
Lordship, impugned order is at page 92, Lordship. 92.
Noted.
issued by the Principal Council Superintendent or Medical Assistant, whereby the Principal Council Superintendent has cancelled the execution of the petition for the cover order number EF for 5/7 and the EF letter number Proceed 25 Proceed sub sub eight entire and after here the contact over the that those and that are and on top of it and the same the sub part and the thing how about or you want
All the respondents, my lord.
how about how about extra check of and take the big order first. So them it return it's after for
Lordship may only clarify one line that I may be allowed to continue my classes and other academic activities. Because I may be allowed to continue my classes and other academic activities because there are projects, research papers and all. Which I understand, Lordship, but for the authorities part, if that clarification is there, it will be helpful for us.
what
Lordship, because
Order is
I understand, Lordship.
Yes.
I understand, Lordship.
Yes, my lord, that's all, my lord, because now he can continue his class and other issues may be decided later on.
17 is also.
17 is also, say, actually, my lord, 14 also will cover this, Lordship. 14 also.
14.
Yes, my lord, same order.
Lord,
Yes,
Lordship,
14, 16, 17.
Lordship, and item 14 and 17, the impugned order is dated 6/6/2010. Only the date is different, Lordship.
Deeply
Obliged,
obliged, my lord.
Lord, this matter regarding provincialization of service. Petitioner before your lordship was appointed as a grade 4 Chokidar in ME school in the year 2008, my lord, as per his appointment letter at page 12. Page number 12. Page 12, my lord. And my lord, his joining letter is, my lord, typed out, my lord, page 13, and the next one is, my lord, page 14. Thereafter, my lord, one act was passed, my lord, by the state government of Assam, and as per the provision of this act, my lord, his particulars was also found eligible for provincialization. Therefore, my lord, it was forwarded to the higher authority as per, my lord, communication dated, my lord, Annexure 3, page 15, my lord. It was dated, my lord, 15 to 2022. Once his name along with other was sent, my lord, his name is appearing at page 16, my lord, serial number 5. Thereafter, my lord, again, my lord, in the same line, my lord, his communication, my lord, page 17, Nectar 4, my lord, it was also forwarded. And this time, my lord, his name in this list, my lord, serial number 12, page 19, my lord. Humble submission is that, my lord, here in this case, my lord, according to petitioner, my lord, is some other, my lord, candidates from this list, my lord, of course, my lord, from other school, my lord, considered by the state level authority, and, my lord, provincialization benefit was granted, which is not in his done in his case. In a, my lord, similar nature, but it is regarding teaching staff, my lord. Another writ petition was decided by this honorable court, my lord. I have annexed, my lord, page 20, and it was also forwarded but not considered. But this honorable court, my lord, directed to consider the case, my lord. Page, my lord, the operative portion at page 24, paragraph 7, my lord. It was provided that when in the case of the present petition, it is contended that their case on verification were recommended by the district level selection committee. However, the further scrutiny that is mandated by the Act of 2017 has not been carried out by the state level selection committee. In the event the petitioner were found to be eligible to have their case considered for provincialization of their cases, the procedure as mandated in the said Act of 2017 is required to be followed, and the cases of the petitioner herein are required to be given its due consideration for provincialization of their services as per the procedure mandated under the Act of 2017. That act is, my lord, they are different, of course, my lord, but procedure is same, my lord. I have stated that paragraph, my lord, 3, my lord.
And
Yes,
Elementary education. Correspondent 1, 3, 4 and 6.
What?
4 and 6. No. One, 3, 4 and
My lord, their act is, my lord, their act is, my lord, paragraph 4, my lord. It is called, my lord, Assam Education Provincialization of Service of Non-Teaching Staff of Venture Education Institution. Act 2018, paragraph 4, my lord.
I'm correct. 5. Yes. Respondent number 1, 3, 4 and 6. 9. 1, 3. 1, 3, 4 and 6. Yes, ma'am. With the 4 weeks.
Pleasure. My lord, this matter regarding compassionate appointment, my lord. Here, my lord, petitioner says, my lord, order of this honorable court to consider his case, my lord, and accordingly, my lord, lordship kindly will look page 25. Page 25, my lord, annexure 4. This honorable court, my lord, already directed, my lord, date is page 26 on 6/10/2023. The matter was remanded back, my lord, to the district level committee to consider his case, my lord. Operative part, my lord, page 27. Kindly, my lord, I may be read out, my lord. In view of the above, we direct the respondent to the district elementary education officer Hailakandi to place the application of the petitioner for compassionate appointment before the next available DLC of Hailakandi district for his consideration. By requiring the order number 2070 of 2025 dated 30th. My lord. My lord.
Initially, I have received instruction, Lordship. Initially, Lordship, the petitioner's mother applied for compassionate appointment, Lordship. Subsequently, Lordship, after majority, Lordship, the petitioner again applied for compassionate appointment, Lordship. But, Lordship, her case has not been placed before the Lordship DLC, Lordship. And subsequently, the 18/9/2024, the notification is, Lordship, issued by the Personnel Department, Lordship, that the all compassionate appointment has been, Lordship, closed, Lordship. Instead of compassionate appointment, compassionate family pension has been now, Lordship. Compassionate family pension has been taken by the Lordship after, Lordship, 1/4/2017, Lordship. That the persons died on after 1/4/2017, they will get the compassionate family pension, Lordship, instead of compassionate appointment. Accordingly, Lordship, Personnel Department issued notification that all the cases, Lordship, all cases, Lordship, that is, Lordship, as per guidelines of the Supreme Court, that are no more consideration, Lordship. Accordingly, Lordship, our court, Lordship, single bench of this honorable court, Lordship, has after hearing that notification, Lordship, that judgment was passed, Lordship.
That is the order dated 3/4/2025.
Yes, Lordship. And in this case, Lordship, he has not, Lordship, submitted the NOK, next of kin certificate also. It is required, Lordship.
Pardon?
The next of kin certificate, Lordship. Next of kin, Lordship.
Next of kin
Yes, yes, Lordship. The petitioner has not provided that certificate, Lordship.
Yes, my lord, it is submitted, my lord. Only, my lord, nowadays, my lord, leave of this honorable court is required, my lord, to consider that DLC, my lord. Because, my lord, as per latest, my lord, notification from the state government, my lord, they abolished the compassionate appointment, my lord. Thereafter, my this honorable, therefore, this honorable court, my lord, passed, my lord, one judgment and order, my lord. Your lordship already referred this judgment, my lord, that to consider, my lord, on merit all the cases, my lord, and to decide, my lord, whether compassionate appointment can be granted or not. But this judgment was, my lord, limited to that group of cases, my lord. Therefore, my lord, we have to approach separately, my lord, before this honorable court, my lord, to get same kind of, my lord, order, so that, my lord, DLC may consider, my lord, on merit my case, my lord. This is the case.
No, Lord. In subsequent case, item number 10, Lordship, the DLC has rejected on the ground of, Lordship, that an next of kin certificate is not enclosed.
No, it is there, my lord. Therefore, my lord, we approached, my lord. Therefore, my lord, we approached, my lord, and this honorable court, my lord, remanded the matter, providing me to submit, my lord, next of kin certificate. And it is there, my lord. But there is a bar for this, my lord, notification, latest notification, 18/9/2024, my lord. Therefore, like document number, my lord, 2070, my lord. Yes. That is 34.
Yes, Lordship.
And there shall also be in the direction
of the deferred topic.
my lord.
Yes.
So the tax of
My lord.
But in this judgment, Lordship, page 32, Lordship. Page 32, Lordship, para 9, Lordship, in view of the consent, Lordship, and
Same. Same.
yes.
Lordship, in view of the consent of the learned council, all the petitions that are pending as on today, Lordship, on 3/4/25 in the Guwahati High Court, which have put to challenge the impugned OM dated 18/9/24 are to be decided as follows, Lordship. All the applications for compassionate appointment submitted by the petition shall be considered and disposed of by the concerned DLC SLC on merit, by taking into consideration the various guidelines prior to 1/4/2017 laid down by the state government for compassionate appointment and the judgment of the Honorable Supreme Court and the High Court. Consequently, the rejection of all compassionate appointments by the DLC and SLC which have been put to challenge and are pending in the Guwahati High Court as on 3/4/2025 are set aside, Lordship. But in this case, on that the petition which are pending before the High Court on 3/4/25, Lordship, that the petitioner is Lordship now he has approached this honorable Lordship. And Lordship, secondly, the entire process for considering various applications for compassionate appointment and the decision taken into each case by the concerned should be completed within a period of 6 months, Lordship, date of receipt of the concerned DLC and but now the petitioner is Lordship.
My lord, may I clarify this? May I clarify this aspect? Lordship, kindly have a look. My lord, this, my lord, this judgment, my lord, in the group case was limited to the, my lord, cases. My lordship, kindly have a look, page 33, last part, my lord. It is, my lord, it is shall only, last part, my lord, of under, my lord, quoted paragraph 10, my lord. It shall only apply to the cases that are pending before the court, my lord, as on 3/4/2025, my lord. Therefore, my lord, subsequently also, my lord, some petitioners applied, appeared, my lord. I also some other petition filed, my lord. Same judgment was also, my lord, disconsidered, my lord, and my lord, same judgment was also provided, and this is one of that judgment, my lord. Paragraph 5, lordship, kindly will look. Learned government advocate Mr. B. Deuri submits that as the petitioner had earlier approached this court by way of WPC number so and the order dated so and so passed in the said writ petition, the cases of the petitioner was remanded back to the SLC. My case was remanded back to the DLC for consideration and further taking into consideration the order dated 4/3/4/2005 passed in WPC number so is the lead case, my lord, and batch of other writ petition. The cases of the petitioner can now be considered by the SLC in its next meeting sitting. Accordingly, recording the submission made by the learned government advocate, this writ petition is disposed of directing the SLC to reconsider the case of the petitioner in terms of the recommendation made by the district level committee Dhemaji on so in its next immediate sitting, if the same has not been already considered. In the event that the cases of the petitioner has not been considered, the outcome of such consideration shall also be communicated to the petitioner court. About case, my lord, this case also will consider, my lord, by the DLC, my lord, for the this judgment of the group case, my lord.
Order.
Yes. But Lordship, he has not, Lordship, submitted the next of kin certificate, Lordship. So Lordship may direct to submit the yes.
The other two petitions are
No, not him.
No,
Not
my lord,
in,
these are not same, my lord. My lord, in the second case, my lord, perhaps they need to submit, my lord, affidavit, my lord. This is little bit
Yes, Lord.
some, my lord,
You have already filed affidavit. Item number 10, Lordship. On 31/7/2025, Lordship, I have filed.
Affidavit submitted. I have noticed it. Yes, submitted. Yes, my lord, as per the observation of their affidavit, my lord, this matter may be, my lord, disposed of. My lord. They are saying that, my lord, there is a case pending, my lord, therefore it is,
Yes, Lordship.
it is not considered.
Criminal case is pending against the petitioner in paragraph 7. So, Lordship,
In terms of, my lord, their affidavit, my lord, this paragraph, my lord, this may be,
it is dismissed, Lordship.
no, this is, my lord, they have
Again,
kept pending, my lord, till result of the, my lord, according to them, my lord, result of this, final result of this, my lord, criminal case.
there is a file in Hailakandi PS case number 67/23, Lord. Under section 417, 468, and 971 IPC, Lord. Paragraph 7, Lord.
Paragraph
of-
7, my lord, is
of
your
the
affidavit.
This petition has to be dismissed.
Yes, Lord.
No, my lord, it is, my lord, they will consider, my lord, they don't know the fate of this criminal case, my lord.
Okay.
Otherwise, my lord, I may be allowed to withdraw this petition, my lord.
Better you withdraw it.
Yes, my lord, to approach, my lord, DLC, my lord.
No, Lord.
No, only, my lord, to approach, my lord.
Sir, yeah, for me, Lord.
And press number 4, Lord.
You for number
4.
4. And Sir David for number
There is an education department.
David.
In this case, Lord, I am appearing for number 2, 3, and Lord,
2, 3,
and
4.
4. Yes, sir.
4, 5, Madam Porwan. And Madam Porwan, you are here? One and Porwan has something that he has the instruction to withdraw.
To approach, my lord, DLC, my lord. To approach, my lord, DLC, my lord.
So it happens to approach the DL.
DLC, I like.
That is not required, Lord.
Because, my lord, he has to, my lord, go there, my lord, they have already submitted evidence, they will, my lord, decide, my lord.
Otherwise, Lordship, that
It is my prayer, my lord.
Accordingly, this date petition then dispose of material. However, liberty will remain with the petitioner to appropriate, no, appropriate for
My lord.
by filing.
Deep level. My lord, next item, my lord, my learned friend will appear.
Yes.
This petition is similar to petition number item number 9, my lord. Only difference, my lord, that item number 9, petitioners already submitted the next of kin certificate, my lord. But this petition will not submitted till date, my lord. I will submit, my lord, as per if honorable court allows me to submit.
Lordship, the case of the petitioner has already been considered in the year 2014, 2021, 2023. The case is of the year 2008, and the petitioner who has applied is now near about had surpassed already 40 also. Since they are availing the pension also, your lordship, and taking into account that already at three instances the matter has been placed before the DLC. So I don't think the harness is there, your lord. Medici and harness. Lordship, the record the instruction is there.
In Excel 6, my lord, page 50, my lord.
Because the scheme is for those cases which has immediacy. So around after 2015, because scheme stopped from 2017. So those matters should gain importance, not the matters of 1992 and this. And without the leave of the court, how they placed again and again that this matter after the rejection by the DLC.
Last rejection, my lord, annexure 6, my lord, page 15. Earlier rejection was not communicated to the petitioner, my lord.
It is equally responsible, the duty of the petitioner also to take the information.
Annexure 6, my lord, page 50. No, my lord.
अपने पेंशन ना पाने के
Pension power. Family. Yes, my
There
only
is-
pension receiving, my lord.
So last time when the case of the petitioner was considered,
2014,
Last time, my lord,
2021,
2024, my lord.
2023.
Next
And
six-
more so, they had availed one order in the year 2009 from this honorable court. So definitely, it is presumed that they have furnished that the same before the concerned office, your lordship. Though now they says that that it even the office says that it was not brought before their notice. But since the fact that the matter has been placed after rejection of the DLC again, so it creates a sort of doubt over the all of the happenings. So whatever be so, matter is of 2008, since it has been placed at 3 instances, lordship, the petitioner cannot have that right, that as a matter of right.
Lordship, kindly see the annexure 6, my lord, page 50, my lord. Annexure 6, page 50, my lord. May I read? Page 50, my lord. This is the order of 2024, my lord. May I read, my lord? Whereas application for compassionate appointment in elementary education department Hailakandi was submitted by Afia Begum Barbuya, dated 30/12/2008, is received against the post of deceased employee, wife of late Rafiq Uddin Barbuya of the department on service, who is mother of the applicant. Whereas after scrutiny of documents by the district elementary education officer Hailakandi, proposal was submitted along with the application before the district level committee DLC meeting held on 19/9/2023, my lord. Next paragraph, my lord. Whereas the district level committee under chairmanship of district commissioner Hailakandi examined the application in pursuance of the honorable high court order, my lord, in WBC number 3777/2009, dated 4/9/2009, and guidelines issued by the government in OM number such and such, dated such and such, my lord. Whereas after those scrutiny of the application submitted, it was observed that the applicant did not submit next of kin certificate along with her application, which makes the application is incomplete. As such, her case is rejected by the DLC as per clause 3 of the OM dated such and such, my lord. This, my lord, order was communicated to the petitioner, my lord. Earlier rejection order was not communicated, my lord. As per the High Court order, my lord, clearly mentioned in paragraph 3, my lord.
Not 2009 order to into number page. Right.
31.
Yes, your lordship. Lordship, yes, your lordship, that second page of my this inspection, your lordship. Second page of my inspection. Lordship, in para 3, case of the petitioner was placed in the floor of the DLC held on 14, and the case was rejected by DLC on the ground that an inlaid, and the case is very old and low stage sports as per existing norm. Same has been recorded in the DLC dated 5/10/2021. Case is very old and low stage sports. Then again, it is in the para 8 also that the case was rejected. The case is very old and low sports here. So it is sufficient, your lordship, because he has been given the enough chance, your lordship, and more so that 2009 order, as he had availed from this honorable, that should have been clearly brought, and there should be a record to that effect that I had submitted the same on this very date after 2009, after availing the order. But there is no such, your lordship, because how can it be taken into confidence that after availing the honorable court's order, he has not went there, your lordship, for availing the benefit? So all of the sequence, your lord, and more so he has been given 3 chances.
The inspection is my lord 2022, my lord.
No. This I have seen, your lordship. Recently, what it has just of the record, I'm saying, taking handle of one communication from the deputy commissioner. They have sought for all of the cases from 1992 and 1990s onwards. I have communicated to them that kindly furnish this particular communication by the DC, but it has not come. Though at one or two thrice instance I have wrote it. So because even in the other matters also, your lordship, if comes into your lordship, will see that the very way they have given, because number of posts in other districts comparatively 10, 12 compassionate appointments nearly come out. But in this particular district, we'll find that amounting to more than 100. And number of DLCs are really more here. So taking all of that, I don't want to go into all of those, but still then, and more so even the next of kin, because what it happens that 6 brothers, they are employed. Now they doesn't annex the NOK. 7 brother now comes and seeks the this compassionate appointment. Now the very scheme is that now, if anyone is not, any employment is not there, they should have to avail the benefit. But knowingly these things are being done. So whatever be so, I'll file my affidavit.
I am relying the one order, my lord, of this honorable court, page 53, my lord. HLS for my lord.
3 and 4. 2, 3. I have my
Lordship, one observation may be given, my lord. During pendency of the writ petition should not be a par for consideration of my case. This observation may be given. Most obliged.
Lordship, date was in 1st September. Can it be a week later, if your lordship allows?
Most obliged.
May I appeal? My lord, there is a case, my lord, because of wrong recording of the, my lord, date of joining in the district level recommendation committee, my lord. His name has been, my lord, left out from the benefit of provincialization. Now, lordship kindly see DLC recommendation at page, my lord, 26.
Yes.
operative part lordship will find at page 29. Page 29, my lord. There is no such serial number lordship will find.
Page 29 is a chart.
My lord, chart. Here lordship will find name. Serial number 8, my lord. Lordship will find, my lord, date of joining 28/7/2011. Page 29, lordship. This is the last page of DLC recommendation. Serial number 8, my lord.
Yes.
Lordship. Yes. My lord, date of joining lordship will kindly see. It has been mentioned, my lord, 28/7/2011. And my lord, right hand side lordship will find remarks, my lord, does not permit as per the Act 2018. Now, my lord, as per the Act, my lord, section 2J, my lord, one must join, my lord, before 1st of January 2011.
But when did you join?
My lord.
When did you join?
Yes, he has joined, my lord, on 28/12/2008.
Where is that document?
Yes, document, my lord, lordship will find at page, my lord, 18. Page 18, my lord. Date of joining. And my lord, handwritten copy lordship will find page 19.
Some earlier also some litigation occurred here, madam. So, madam, notice may be issued so that I can get the status of this.
Now, having my lord, seen the my lord, situation, he has filed an appeal before the my lord, respondent authority. Lordship will find at page 34. Only limited prayer, my lord. Let my date of joining be corrected. Let it be placed before the SLC. My lord, page 34, my lord. Page 34. This is limited prayer, my lord. Therefore, you are requested to rectify my original date of joining as paragraph 2, my lord, 28/12/2008 in place of 28/7/2011 in the recommendation submitted by the District Scrutiny Committee Dubri in respect of so and so Madrasa against my name and provisionally my service as per third assistant teacher as per section 2J 1311 and 1312 under the Assam.
So what happened thereafter?
Yes. Thereafter, my lord, no such response was given. Then petitioner approached this honorable court and there is an order passed lordship, my lord, at page 38. Page 38. And operative convert page 40, para 5, my lord. Page 40, para 5. It says, my lord, the petitioner shall serve a copy of this order upon the respondent number 6, along with a copy of the writ petition with all enclosure for doing the needful. The writ petition stand disposed of in term. Now, thereafter, my lord, he has filed representation again, my lord, before the respondent number 1, lordship will find at page 42. Communicating the High Court order, page 42.
Page 40?
42 minutes.
Thereafter?
Commissioner Secretary. Then, my lord, again, my lord, page
43, Lordship will find another communication, similar Western mallet by the petitioner, page 43. This was before the Director, Secondary Education Assam. Page 43. No response. Then my Lordship will find there was again a communication from the Inspector of Schools, because the petitioner filed application before the Inspector of School also, page 44. And responding that, the Inspector of School has requested the Director of Secondary Education Assam to do the needful, page 44. Lordship has seen, page 44.
Yes.
Same issue. Then, my lord, surprisingly, my lord, the Lordship will find page, my lord, 45. The letter dated 14/8/2023. There, Lordship will find page 46, my lord, paragraph 3. Page 46, paragraph 3. May I read this, my lord, relevant portion, my lord. The state level scrutiny committee examined the matter through the recommended the name of so and so, so and so, so and so, so and so. These are the name for provision of the service in so and so school under Dhubri district as per recommendation made by the state level scrutiny committee. Necessary proposal for the creation of the so and so post incumbent, including the name of so and so, has been submitted before the court. Now again, my lord, petitioner name has been, my lord, dropped out. Now others' name have been already recommended by the state level scrutiny committee.
Whether your name was considered.
My name is not here, my lord. Page 46. Page 46, para 3, my lord.
Now, what is your pair?
My lord, my limited prayer, lordship, kindly see page, my lord, 14. Page 14, my lord. Mandamus should be issued directing the respondent, particularly respondent want to rectify the date of joining of the petitioner as 28/12/2008 in place of 28/7/2011, and to place the recommendation of the district scrutiny committee of so and so before the state level scrutiny committee SLC for provisional, for the purpose of provisional of service of the petitioner. That was the limited prayer, madam. Let them rectify and let it be placed before the SLC. Unless there is a rectification.
Are they not supposed to verify the
My lord.
verify your document?
My documents, my lord.
Yes. So passing such product.
My lord.
Whether the respondent authorities are not supposed to verify the document.
Yes, definitely, my lord, definitely. They will verify that document. After verification, my lord, yes. That is limited.
My lord, section 2, schedule 2, J of the 2017 Act, page 103.
Section J.
J. May I read, my lord? Page 103. J. Employee means and includes all servicing teachers and tutors, as the case may be, of venture educational institutions who have been appointed and joined in the concerned venture educational institutions before the first day of January 2011, and whose services are being or would be provincialized under this act. My lord, he was not joined as per that report. He was not joined before the first day of 2011, my lord. And he was joined here, my lord, 28/7/2011. District scrutiny, as per report of the district scrutiny committee. So, my lord, notice may be issued here, my lord. The department can verify and file the affidavit.
Page 19, Lord. The page 19, Lordship has already seen my date of joining.
They are supposed to verify.
Yes, definitely.
Let them,
Well,
Nasir Mundal Memorial High School now. Well,
High school. And that for the purpose of
No, man. I am for the respondent number 2, 3, 4, 5, and 7.
I'm reading on behalf of BT. His name may be recorded on the respondent number
1 and 6.
1 and 6.
1 and 6.
1 and
what
BT.
Video.
1 and
6. Like.
1.
And extra copies may be furnished.
Please the matter first. We
Fifth, my lord.
after the text or by after tips.
Obligation.
May it please your lordship. Lordship, here the petitioner is the cousin brother of late lordship, late Jyoti Prasad Sharma, who was ex-service teacher. Lordship. He is claiming the service benefit of the respondent. A respondent height annexer 3 lordship, page 16 lordship, directed to submit the legal hair certificate and succession certificate. Lordship. These were submitted.
My lord. Here, my lord, he is claiming salary of the petitioner's brother, but petitioner's brother was expired on 17/12/2008, my lord. It is long back ago, my lord. So, my lord, notice may be issued here, my lord.
No, if he the only legal hairs left behind by the it affect the benefits.
Yes, my lord. But, my lord, as per our High Court, High Court has observed some, in some cases that 3 years is the period to claim the area, to claim the salary or other benefits.
Whether
my lord.
that observation will help you.
So, my lord, notice may be issued, my lord.
When you file the application or
To claim the service benefit.
Yes.
To claim the service benefit.
Yes.
For payment of provident fund, leave of absence, gratuity.
When?
Initially, it was filed on in the year 2014. He communicated the same in 17/12/2008. That was communicated in 2008.
2008.
2008.
What is that letter?
That letter is not an act, but the communication made communication was made also made in 2014. That is annexure 2. Annexure 2, the last para, where he submitted petition on 1/10/2012.
Annexure 2.
2. For information, the last para which refers to his petition dated 1/10/2012.
There is also one next of kin certificate.
Yes, next of kin certificate is there.
For 27.
So, notice may be issued in the meantime. Department will verify the claim whether he is really entitled or not.
So there is one succession.
Yes, succession certificate also there, and next of kin certificate also there, ma'am.
Then what more documents you want?
My lord, claim is from 2008, my lord. So, my lord, some time may be required to department to examine the matter. My lord, notice may be issued in the meantime. Department will get the time also to examine the matter.
When succession certificate
Yes.
was issued.
Yes.
And next of kin certificate was produced.
Yes.
What is the bar in the benefits? Better you obtain instruction.
Yes.
Or sir?
As this one.
The service benefit record by the and next subject picture of the cases that yes, it's not the surviving legal heir of the former Garnet that the petition was valid to the sort of service that subject is that in which subject subject is of person cases and he died on the 12,008 year vehicles surviving legal heir of the 20,000 sort presently has obtained act of insert office of the deputy teacher and also obtained the insert under the something to the section by and subject the same for the third benefit of it to the sort but the thing not yet indicated whether uh, sub predecessor not important normal learning nothing for you are for respondent number
Phone number 1, 2, 3, and 4. All are responding.
obtain methods correct specified benefit service benefit or above this
In the meantime, extra copies may be served to us.
normal learning
Right.
Yeah, please, Your Honor. Here, the petitioner has challenged the appointment of private respondents, Your Lordship. They have already been appointed, Your Lordship. On the ground as a graduate teachers under BTC, Your Lordship, on the ground that on the last date of submission of application form, Your Lordship, they did not possess the requisite educational qualification, that is the B.Ed, Your Lordship. They are still doing B.Ed, Your Lordship, and on the last date of filing of the Your Lordship application form, they did not possess it, Your Lordship. That's the ground on which we have put their appointment to challenge, Your Lordship. In the meanwhile, all of them were appointed 2 months back, Your Lordship. Probably I don't have any interim period, Your Lordship. Let notice be done, Your Lordship. Let them come. Advertisement, Your Lordship, will get that page 30, Your Lordship. And page 34, your lordship will get the relevant clause, your lord. Serial number 12, your lordship. The candidates having not clear status against any qualification will not be eligible to apply. Not only applied, your lord, they have your lordship given appointment.
Late notice go, already appointed, my lord, the private respondent. Correspond now 1, 2, and 3.
The appointment of private respondent for
37.
for 37 as undergraduate teacher.
Lord, graduate.
The direct meetings protocol order of the public party there yet
Lord,
and not the scheme. And as for advertisement, it's 13 February 2024. That's for
12, your lord.
12 of the criteria of other criteria in the advertisement of the that is having not clear we can insist that the against the qualification and the private respondents have not completed the yet degree. And despite of the effort they have applied, they have fought, they have worked under the audit for which they have been taken by the ATM of however, it would the board under that office. However, extradited state of the part did the matter after
May I make a prayer, your lordship? So far as 4 to 37 is concerned, your lordship, exact players posting we don't have any knowledge, your lordship. Therefore, we are praying that this we may be allowed to serve them through the Directorate of Education BTC, your lordship. Exact address we don't have.
The petitioners are not aware of the exact address of the private number for that is interest according permission for the office of the director. It is
The Director of Education.
Director of Education.
the number
Hello, respondent number
3, your lord.
3.
number
Deeply obliged. Here, your lordship, the petitioner, your lordship, as per the policy of the government, your lordship, applied for your lordship transfer from his present posting to a circle, your lordship, called Ognikobi at Biswanath Sarial, your lordship. And if your lordship comes to page 22, your lordship will find that he was, your lordship, his appointment was approved by the Director of Secondary Education, Assam, your lordship. Page 22, your lordship, Annex 3. Now, within 10 days, I was directed to your lordship, join in the new place of posting, your lordship. But your lordship, the concerned headmaster, your lordship, is not releasing me from my present place, your lordship. That's why I have not been able to join, your lordship. That's my grievance, your lordship. Your lordship will find, your lordship, the order of transfer at page 14. And I have also represented before the authorities, your lordship, more particularly principal, your lordship, of the school. But your lordship, to no avail, your lordship. Matter is pending at such, your lordship. My transfer order, although your lordship, I was supposed to be there within 10 days. Your lord, page 22, your lord. In pursuance of the government approval on the recommendation of state level committee to transfer and posting of a teacher under secondary education and communication by so and so, and as per provision of the Assam Elementary Secondary School Teacher Regulation 2020, the following teacher is hereby transferred as per his or own request, own grade and scale of pay with effect and posted in the district, shown against his her name. Name, your lordship, Osim Bora. Which is he is presently in your lordship, Jamuguri Adarso High School, your lordship. Now he posting, your lordship. Yeah. Posting, your lordship, nowadays, your lordship, I will have to report to the DEO of the district elementary education officer, your lordship. Then he will post me, your lordship. That's why your lordship will see name of the district where posted, Vishwanath, your lordship. The teacher will be instantly released by the head of the school. Will report to the inspector of schools of newly posted district within 10 days from the date of issue of this order. Second condition, your lord. Thereafter, the district level committee has not been releasing you. Not releasing you, although there is a direction from the director. Yes, Mr. Sharma.
So, my lord, I have to take instruction regarding that, my lord.
For the inspection, we will
Yes.
take it up at 2 o'clock.
My lord, we are not representing the headmaster, my lord. So,
Pardon?
Sonipur. We are representing on the.
Deeply obliged.
The matter relates to the arrear salary and the suspension period, the allowance, my lord, which has not been paid to the petitioner, my lord. Already petitioner has been retired in 2017, lord. And the last occasion, my learned friend requested before this honorable court to produce some relevant record. My lord, here in the case, lordship will find the case, my lord, in terms of the honorable this suspension order, lordship kindly have a look at page. No, instruction, sir. I have already filed my affidavit, my lord, and the records are available, my lord. This is the record. May I go?
The matter is ready for this.
Yes. This is a pardon matter. It is up to your lordships to consider.
Yes.
Let lordship kindly have a look at page 23, lordship. Annexure C. In pursuance of this order was passed on 5th February 2012. My lord, in pursuance of Secretary BTC by number so dated 27 January 2012 and pending drawal of departmental proceeding, Sri Devi Prasad Himire, Assistant Teacher, Siddhesar ME School, under BEO Govardhana of Baksa District is hereby placed under suspension with immediate effect. And he is allowed to draw 50% subsistence allowance under FR 53(1)A with the condition that during the period of suspension, he will put signature in the teacher's attendance register from the very beginning and ending of the school hours. Well, these conditions is not tenable. Still, I am reading this this contents, my lord. Now, after that, my lord. Next page, my lord. Page 24. My lord, this suspension order was issued only because of the dispute in between the headmaster and the petitioner, since there was a dispute for the headmastership, my lord, considering the seniority. And the petitioner was the senior most, but otherwise he was deprived and he did the cases, my lord, before this honorable court. And as a result, my lord, this suspension order was issued. Lordship kindly have a look, 3rd June 2013. My lord, this is an order passed by the Secretary, my lord, Bodo Territorial Council, my lord, 3rd of June 2013. In partial modification of the Secretariat letter number so-and-so, dated 35/13, and the interest of public service, Sri Devi Prasad Himire, Assistant Teacher of Siddhesar ME School, is hereby reinstated and transferred to, he has been reinstated. Suspension order was there, and this suspension order has been revoked and thereby reinstated. And thereby, he has been transferred to Madhya Hauli ME School in the vacant post arising due to expiry of Narayan Chandra Das, Assistant Teacher of the school under Govardhana Education Block of Baksar District. Earlier, he was in Siddhesar ME School, and subsequently, because of the dispute, he has been reinstated and transferred. This is the order on 3rd of June 2013, madam. And subsequently, next page, lordship. Hmm. 22nd of August 2013. As per the approval of Secretary Education BTC Kokrajhar, hide approval order memo number so-and-so dated 30th May 2013, Sri Devi Prasad Himire, Assistant Teacher of Siddhesar ME School in the district of Baksa, is hereby transferred in the same grade and pay and posted at Madhya Hauli ME School against the death vacancy occurred due to late Narayan Chandra Das, Assistant Teacher under BTC area. He is directed to join the school within 7 days from the date of receipt of this order. No TAD will be admissible for the purpose. This is an order from 5th February to 22nd August. There had been 19 months, 5 days suspension period. From 5th February 2012 to 22nd August 2013. Since he has joined on 10/9, my lord, up to 9/9/2013, I have stated in para 4, my lord, he has joined in the post in the new assignment on 10/9/13, and up to 9/9/13, my lord, there will be 19 months, 5 days suspension period. Up to 9/9/13, my lord. On 10, he joined in the different school.
19 months.
19 months, 5 days, my lord. This is the suspension period. And otherwise, my lord, the arrear salary, lordship.
As per this annexure D, was included and transferred.
Yes.
Howley ME.
Yes.
And thereafter, again he has been transferred.
No, but this is a continuation, my lord. This is
Subsequent order.
director's order. Earlier, secretary's order. Subsequently, director's order. Then subsequently, another order was there, my lord. That is inspector's school's order, which was supplied to me in letter stage. And on receipt of the same, I have joined in the school on 10/9/2013, lordship. I have stated in para 4, my lord.
What is that order?
That order, it is not there, my lord, but it is joined on 22nd, whatever I have found, my lord. It is enclosed, and subsequently, when I have been told to join, already I have joined, and since 10/9/2013, I got the salary, my lord. I got the salary, I have retired, and I have retired on 31st of January 2017, lord. Well, all the salaries and with effect from 10/9/13, I have got it.
Retired on
31 January 2017, lord. From this Madhya Howli ME school, lord. And lordship, when I joined, my lord, meanwhile, my lord, I came before this honorable court for the arrear salary, my lord. For the arrear salary, for the period from March, arrear salary with effect from 23rd of March 23/3/2010 to as a whole 9/9/2013, lord, including the suspension period. The arrear salary, it starts from arrear salary, my lord, it is that is given, my lord. That is arrear salary from 23/10/2010 to 4/2/2012. And the suspension period from 5/2/12 to 9/9/13. The arrear salary will be 15 months, and the suspension period for 19 months. 19 months, 5 days, 5 days. Here it is 9 days or something. It should be 9 days, my lord, not 5 days. 19 months, 9 days, my lord. Now, my lord, in terms of this honorable court's order, lordship, as enclosed annexure F, lordship.
Salary for the substantive was not then to you. Applying the principle for no pay.
Yes.
Right?
Yes. My lord, no work, no pay will not be applicable because there is a settled law, my lord. When person is supposed to work, if he has been devoured by somebody else, then this no work, no pay will not apply. And lordship will have a look at rule FR 54B, my lord. It's very clear.
FR 54B.
B. There was no disciplinary proceeding, my lord.
Against the present petition.
Only suspension because of their dispute with the headmaster, my lord. That's all. No disciplinary proceeding. May I read, Lord? FR 54B, when a government servant who has been suspended is reinstated or would have been so reinstated, but for his retirement on superannuation while under suspension, the authority competent to order the reinstatement shall consider and make a specified order regarding the pay allowance to be paid to the government servant for the period of suspension ending with the reinstatement or the date of his retirement on superannuation as the case may be, and whether or not the said period shall be treated as period spent on duty. My lord, 2. Notwithstanding anything contained in Rule 53, where government servant under suspension dies before the disciplinary or court proceeding instituted against him are concluded, the period between the date of suspension and the date of death shall be treated as duty for the all purposes, and his family shall be paid the full pay and allowances for that period to which he would have been entitled had he not been suspended, subject to adjustment in respect of subsistence allowance already paid. Now, 3 is very important. Where the authority competent to order reinstatement is of the opinion that the suspension was wholly unjustified, the government servant shall, subject to the provisions of Sub-Rule 8, be paid the full pay and allowances which he would have been entitled had he not been suspended. And provided it is for termination, provided that where such authority is of the opinion that the termination of the proceeding instituted against the government servant had been delayed due to reasons directly attributed to the government servant, it may, after hearing the representation, if any, submitted by him, direct for reasons to be recorded in writing that the government servant shall be paid for the period of such delay only such proportion of such pay and allowances as it may determine. Or in case of falling under Rule 3, the period of suspension shall be treated as period spent on duty for all purposes. 5. In cases other than those falling under Sub-Rule 2 and 3, the government servant shall, subject to the provisions of Sub-Rule 8 and 9, be paid such proportion of the full pay and allowances to which he would have been entitled had he not been suspended, as the competent authority may determine after giving notice to the government servant to the contempt proposed and other considering the representation, if any, submitted by him in that connection within such period, which in no case shall exceed 60 days from the date of notice which has been served as may be specified. It is not this question doesn't come because no notice was served to me in this regard. Only this clause 3 will be applicable in my case.
clause 3 will be applicable. And this clause 8, the payment of allowances under 6. 6 is also, my lord, where suspension is revoked pending finalization of the disciplinary or court proceeding. And now,
Disciplinary proceeding was brought up again.
no, my lord, that is why, my lord, the question doesn't arise. Only suspension was made on the ground that there is a dispute between the headmaster and the petitioner. Because petitioner was the senior most, he has been deprived, he filed the writ petitions. That is why under the grass, this headmaster took the steps saying that he is not allowed to work and sign in the attendance register.
How for area salary?
Arrear salary and the suspension period this allowance.
Area salary for
With effect from 23/3/2010 to 4/2/2012. Arrear salary. And the suspension period 5/2/2012 to 9/9/2013. And this honorable court was also pleased to direct the respondents to consider the arrear salary of the petitioner by virtue of the honorable court's order dated 28/4/14, my lordship.
38.
Lordship, the page 26, lordship, annexure F. The para page 29, lordship. The second para, my lord. The whole basis of the prayer of the petitioner in WPC 6522/2013 Siddheswar ME School is that the petitioner did not attend his duty from so and so 22/8/10 to so and so. That is till he was transferred. No, lordship will find at page 28, my lord. Lordship will find page 28. I'm just reading, my lord. In the first writ petition, WPC number 1802/2014, filed by the petitioner, my lord. The prayer of the petitioner is to direct the respondent to release his salary, both arrear and current, stated to be payable from March 2012. It should be 10, my lord. That has been pouring on has been passed, my lord. Another order has been passed. Page 31 order was passed, my lord. It should be March 2010 instead of 12. The petitioner is on ME school teacher and he was transferred from Siddheswar ME school to Madhya Hauli ME school. Filed order dated 22/8/2013 and he joined the school on 10/9/2013. Thus, according to the petitioner, he is entitled to receive salary from March 2000. It should be 10, my lord. 10 to 9/9/2013 in his earlier school, namely Siddheswar ME school, and from 10/9/2013 in the new school, namely Madhya Hauli ME school. And this was my contention. And the school authority also came, my lord, that time. And they have raised some of the question, my lord, here. And accordingly, this honorable court, lastly, lordship will find, above being all disputed questions of facts requiring ascertainment of the veracity of the or otherwise of the pleas taken by the petitioners involved in the proceeding, it will be appropriate for the BTC authority to ascertain the real state of affairs in the matter and then to take appropriate decision in the matter strictly in accordance with law. Accordingly, both the writ petitions are disposed of, directing the BTC authority to resolve the issue as regard the payment of salary to the petitioner in WPC so namely Devi Prasad Gimire, for the aforesaid period, taking note of all attending facts and circumstances and in accordance with law. In the process, the said authority may hear the relevant parties, including the parties involved in this proceeding. Let the required exercise be completed by the BTC authority as expeditiously as possible, preferably within so and so, by passing a speaking order. As regard the current salary stated to be payable to the petition involved in WPC number so and so in new school, the BTC authority shall take appropriate decision immediately, preferably within 10/5/2014. Now, the another order, my lord, page 31, that wrongly there was a March 2012, so it was corrected as March 2010, the arrear salary, my lord. And my lord, accordingly, the petitioner submitted application. Then, meanwhile, Lordship, kindly have a look. Page 34, my lord. Page 34, in 2017, I came before this honorable court. And this case, 17, my lord, just after the retirement, paying for this pensionary benefits and all. Pensionary benefit, revised pay scale, and senior grade, as well as the arrear salary, my lord. This honorable court, after about 2 years of pendency of the writ petition, my lord, finally, it was decided on 25/9/2019, my lord, after pendency of 2 years, my lord. But here, my lord, BTC did not file any affidavit, my lord, in the case. In this case, no, that
he is speaking about writ petition number 7383/2017. That was disposed on
25/9/2019. That's page 34, Lordship. Page 34.
Yes.
I'm talking about this, my lord. That time Bora was not there. And when the matter was pending for 2 years, my lord, no such affidavit was filed. And accordingly, the honorable court came to the conclusion with a direction to release the arrear salary as well as revised pay scale and also the senior grade pay if the petitioner is found to be entitled.
Order, whether any order was passed.
No, in this case, my lord, when there has been a communication, my lord, on the basis of this order, my lord, next para 37, my lord, page 37, I submitted application, my lord, 37 and 38 and 39, my lord. 39, I've got a communication, my lord, from the district elementary education, to director, where it has been mentioned about the order of the director dated 26/12, para 41, Lordship. Para 41. This is a communication of the district elementary education officer to the director of education BTC, my lord, where in page 41, Lordship, annexure 4, this order was enclosed, my lord, 26/12/2014, my lord. And when the matter came to the notice of the this petitioner has again challenged this this order 42, my lord, had challenged before this honorable court by filing this writ petition, my lord. This notification 26/12/2014. Now, in the present writ petition, I have challenged, my lord. When it has come to the notice of this petitioner, and 43, my lord. Before going to 43, my lord, let me have this 43, my lord. Before going to 42, this impugn order. 43, prayer for providing a copy of Office Order 26/12/2014 issued by the Director of Education. Rightly, wrongly, it was not with me, my lord. That is why it could not be challenged. So, my lord, subsequently, I have challenged this order, my lord. This 26/12/2014, my lord. My lord, what the 26/12/2014 said, my lord. The Director Education report. May I read, Lord? It's Lord. Now time is. It will take time, my lord, some at least for 15 to 20 minutes. For half an hour. Here, the gist of the case is this, my lord. Since, as per this rule, it says that when my suspension has been revoked, automatically this person is entitled to this suspension allowance. Not a single coin was paid to me at that time, my lord. Not a subsistence allowance was paid to me. And
whether immediately after
yes, and thereafter I got the salary.
after
Yes, I got the salary. Only the suspension allowance has not been paid, and the earlier arrear salary. And earlier also they did not pay the. In earlier occasion also they imposed me suspension because of this dispute. This honorable court has a specific direction, Annexure A, my lord, where this honorable court said that no, this way you cannot do. You pay the suspension allowance as well as the arrear salary to the petitioner. That order was there, and you cannot discontinue the arrear salary. There was a direction, but even then, having this specific direction of the honorable court, they did it. They did not pay the arrear salary. So now only for these 42 months, but
earlier
he was suspended because of the headmaster's dispute, my lord. Only that part. Yes. Because the headmaster
salary of earlier
that has been paid, my. That has been paid. When the contempt case was filed, then they have already paid the amount. Earlier one. They came to the court and showing the receipt of payment, and accordingly they paid the amount. Then the contempt was closed on payment of the salary. This order I have enclosed now. This order as well as the contempt petition, this order. Annexure A and B, it will be. And that is why, my lord, here for here my learned friend
that from 10 of 12 arrears
Lord.
Then 5 of 12 suspension.
Yeah.
For this period, you are entitled to salary.
Lordship.
That is your case.
Yes.
Then they have applied the
Yes.
then that order is
Yes.
that is
Yes. And that too, Malat, here, once a person has been reinstated, the rule is specific, Malat. Once it is revoked the suspension, I'm entitled to the whole salary, Malat. The full payment. It says, and even the settled law of this.
fine, but the order you have joined it for
Exactly, Malat. I have joined. When I have got the order, I have joined and I have continued in the different dispute. Then I have been transferred from where the dispute arose for headmastership. I have been transferred, my lord, because of this dispute. And here, my lord, nothing more, only for the headmastership dispute, my lord. Whole root of the case, my lord, it's a dispute for headmastership.
come to this order, impugn order, annexure L page 40.
Annexure.
There it is mentioned.
Which order,
That
Lord?
the record says page number 14.
Page
14. The record says that he was not in work from March 2012 9 September 2013. Hence, he is not entitled to payment of salary for the same period.
This
on the principle of no work, no pay.
This fact, my lord, I have also brought to the notice of the earlier court's order. It has been written, my lord.
No, that was observed that this disputed question of fact cannot be decided in great person. Then how can we decide it now?
No, my lord, here, my lord, this this payment, my lord, regarding this salary payment, this area salary for the period from 10 March, 23 March 2010 to 4 February 2012. This period, my lord, this 15 months period, let them verify and pay the salary. And my lord, this part, my lord.
That direction was already there in the earlier repetition.
No, earlier read petition, that is why, my lord, earlier read petition, they have passed a speaking order, my lord, that next lordship. That is why I have this on the basis of the court's order, they have passed the speaking order, page 42, lord.
Yes.
Page 42. May I read? Seen the order of so and so of the Honorable Guwahati High Court.
You have already pointed out about this order.
Lordship.
Here it is mentioned that regarding the principle of no work, no pay.
Yes. Yeah, it is there, my lord. Lastly, my lord, just the third pair I am reading, my lord. The last one, my lord. From January 2000, they have said the petitioner, it will be very toughest, my lord, to go through it since it is small. My lord, may I read, lordship, from third paragraph? Then it will be clear. From the report stated above and material available in records, it is found that Sri Devi Prasad Dhimire, assistant teacher, Siddheswar ME School, physically assaulted Sri Jagat Bahadur Pradhan, the then headmaster of the said school. Consequently, he was placed under suspension by the DO Baksa by his order memo number 7/11/2008. And then after DO Baksa reinstated him in service by order memo number 23/10/2010. However, he did not report in duty after his reinstatement in service, as the instant petitioner was non-complying of the authorities' direction and negligence of duty. the BTC by letter number so and so dated 27/1/2012 and this directorate memo number so and so dated 5/2/2012 place him under suspension. Now he is working at Madhya Hauli ME School as per transfer order issued by the Director Education by order memo number so and so 22/8/13. The record submitted by the headmaster Siddhesar ME School, he is the culprit, my lord, headmaster, says that the petitioner had received salary up to February 2012 amounting to rupees 5,31,650 only in spite of the remain absent from duty. The petitioner was unauthorized absent in his duty from January 2011 to 9 September 2013. So far as the teacher's attendance register of the Siddhesar ME School is concerned, the record says that he was not in work from March 2012 to 9 September 2013. How he will work? He has been suspended. How he will work? Hence, he is not entitled for payment of salary for the period on the principle of no work, no pay. How he will work, my lord? Since he is under suspension, the instant petitioner of the case found attending in his duty at Madhya Hauli ME School from 10th September 2013, as such his current pay bill have been submitted to the Secretary BTC by the BO Govardhana for the period with effect from 10/9/13 to November 2013, and the same is under process to pay soon. After consideration of the case, the claim of the petitioner is prima facie does not seem to be adequate as reports of the concerned district authority and headmaster of the school, who is allowable for arrear salary with effect from 10/9/2013 to November 2013, and hence his claim for payment of salary to till that is herewith rejected, having no merit, none is as per rules. This payment has already been paid. Why he is saying so? But only salary 23/10 to till date is herewith rejected, having no merit. This is issued in tune of so and so of the Guwahati High Court order WPC number so and so. Now, this has been a challenge before this honorable court on the basis that since from 5th of February 2012 to 9/9/2013, he was under the suspension, and once the person has been suspended, how he will work? And once the rule says that once the suspension is revoked, meaning thereby the government employee is entitled to the whole salary amount as per the law. And there is also the Supreme Court as well as our High Court has said, once the person has been reinstated, he is entitled to a full arrear salary without any discrimination. This part, my lord, I will show the law, my lord, regarding this thing.
Okay.
Lordship, little
Standing order, okay.
Lordship, before starting, I just having one thing, Lordship. Okay, again, Lordship, as because tomorrow, Lordship, because I submitting on base of page 12, Lordship. Page 12, I'm submitting this because of this, Lordship. I'm going through the record, Lordship. Page 12, paragraph 12, that's going to over 24 August 25, Lordship. 24, Lordship, this is 18, Lordship. Tomorrow, nothing will happen, Lordship. That's why I'm submitting, Lordship. As this is
Already, my lord, I have been restrained to perform
No,
my
he's
duties by
continuing
the
now.
respondent number 5, my lord, without any.
Tomorrow, then, oblige us. Lordship, 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 Lordship. Deeply obliged.
এই ইনষ্ট্ৰাকশ্যনটো যে এনেকুৱা 24
সেইটো আছে নেকি লছটিপ can take up 5 minutes instruction is in typing then in Sunit Polar I said that inform that he is typing out the instruction lordship that's just after 5 minutes.
Otherwise, can we take it up?
Yes also yes tomorrow yes or day after tomorrow lordship or day after tomorrow yes
Put up there. Secretary,
a secondary yes okay মাত্ৰ পঢ়াই দিব
Here, my lord, one letter has given by the director secondary education to elementary education, and regarding the report of justification regarding the entitlement of the incremental benefit and pending arrears of the petitioner. So still it is not coming from the elementary education department. So my lord, some time may be given to us so that we can collect the report from the elementary education department. From the elementary side and
Not a party, but I have informed the director. Here, my lord, the petitioner earlier used to be in the elementary department. Subsequently, their services were amalgamated. Therefore, a report from the director has been called by the director second. Lordship, give us which type of is the becoming article.
Last time, even lordship already time.
and otherwise this is my instruction regarding that money.
or sort of or Secretary, or or not. Or- Secretary, Asar, I- Right. Right. Okay. Third, fifth, sixth, interesting. Wait, that's a which sign here of that of of sector part X.
Hello.
Well, in this case, the lordship asked me about the earlier order, page 16. Page 16, earlier I came before this honorable court. Relevant portion 18, lordship. Page 18, lordship. It is very important, my lord. Small order, I will read out, my lord, so that it will be easier to understand, my lord. Heart so and so and so. Second para. While working as assistant teacher in Siddheswar ME School, Borpeta, on regular basis, the petitioner was placed under suspension by respondent number 3, namely District Elementary Education Officer, Borpeta district, and Musalpur, Baksa in the month of November 2008 without assigning any reason therefore. During the period of suspension, the petitioner claims that the subsistence allowance was not paid to him. On the objection being raised by the petitioner against the said order of suspension, the same was revoked on 23/3/10, and the petitioner came to be reinstated. The petitioner's grievance is that though he has been reinstated, his salary and allowances have not been paid for the period during which he remained under suspension with effect from 17/11/2008 till 22/3/2010. And he has also not been paid his current salary with effect from the salary, that is the salary after he stood reinstated. Appearing on behalf of the respondent number 345, Mr. Das, learned Standing Counsel BTC, submits that the delay in payment of the salary and allowances of the petitioner has been due to the fact that the headmaster of the said school, had not prepared the requisite bill for payment of salary and allowances to the petitioner. But the dispute has now been sorted out, and the payment of salary and allowances of the petitioner would be made within a short period of time. Considering the matter in its entirety and in the interest of justice, this writ petition is disposed of with a direction to the respondent authority, particularly respondent number 5, namely Borough Territorial Council, represented by the Secretary Soencho Pokrada, to ensure that the petitioner's salary and allowances, both arrear as well as current, are within period of 8 weeks from today, made available to him. If for any reason the headmaster of the said school delays the preparation of the bill of the petitioner, respondents, particular respondent number 5, namely Borough and Territorial Council, represented by the Secretary Education Department, Pokrada, shall remain at liberty to take appropriate disciplinary or penal action against the headmaster of the said school in accordance with law. No order is to cause. Now, Lordship will find the contempt petition, Annexure B. Next page, my lord. Annexure.
That has already been paid.
Yes, this page
Why you are
22. No, my lord. I'm just saying that earlier period, whatever the suspension period was there, that has been from 2008, my lord. On the basis of the honorable court's order, that amount, Lordship will find the amount 5,31,000. Here 22, my lord, in the contempt case. The explanation given is accepted. The personal appearance of the respondent is dispensed with. It is submitted by the respondent number 2 as well as Mr. Das, learned counsel so-and-so, both the respondent number 1 and 2, that the order passed by this court on so-and-so 12/8/11 in WPC number 111/2000. Lordship. Lordship.
That amount has already been paid.
Yes, 5,31,650 is paid in my bank account, madam. Now, by virtue of this court's order, my lord, I was allowed to continue and to pay the arrear salary. But meanwhile, now this salary has been stopped, and whatever the pending salary that has been paid, but after the reinstatement, the arrear salary has again been remained. I have been reinstated on 22/10/2010, 22/9/2010. From 23, this arrear salary is pending again. But where is this honorable court specifically directed, my lord, to allow him to reinstate the petitioner as well as to pay the arrear and current salary. This current salary has been stopped. This is totally violation of the court's order. And that is why, well, at this 2012, when they have they stopped the salary, I repeatedly submitted my representation and requested the authority concerned. only because of this dispute in between the headmaster and the petitioners, this root cause has arisen, my lord. Otherwise, I would not have been suspended or something action would not have been taken against me. Now, Lordship, in this respect, my lord, my friend has filed an affidavit. He has filed an affidavit and raising some technical the issue that since that Lordship will find their affidavit at page continuous page 49, my lord. Lord.
Yes, Mr. Bora.
And if necessary, I will rely on the decisions, my lord.
If necessary, I will accept.
Lord.
Mr. Bora.
Lordship.
Paragraph number 9 of your affidavit. It's back part of page number 3.1. The period 5 to 2012, 9, 9, and 13 that petitioner have not attended the 5 of 12. Got it?
Lordship.
Is there any provision that during the period of suspension he have to attend the classes?
There is no, my lord. Lordship will turn, therefore, Lordship will turn to the page number 23 of the EPD.
You first answer my question.
No, so that's a Lordship is in that FR 53. FR 50, Lordship will, they have to turn to the writ petition, page number 23. That is order dated 5th February 2012. That is clearly stated in the paragraph, second paragraph, my lord. And this suspension order has never, he has never challenged the suspension order. He accepted it. It went on. Then came the next phase of modification. Once it is revoked, how can it be challenged? But thereafter, it was passed on 2020, 5th February 2012. Modification was done on 3rd June 2013. He never challenged this provision, my lord. And subsequently, what had happened, my lord?
Are you justified in putting such a clause?
No, even it is wrong, my lord. He should have challenged it. He have never challenged it. It went on. Now today also in the petition, this is not the challenge.
Whether such a situation is contemplated in the FR 53 1A.
FR 53 that subsistence allowance. No, I have gone through it. FR 53 that he will get the subsistence allowance of 50%.
You see the provision under which that direction was issued.
That I have gone through it. There is not that is not there. That is not there. But he has not challenged it. It was there. He has not challenged it. Till date, he has not challenged it. And Lordship will see how frequently there is some water development.
If he is not challenged, are we not supposed to examine it?
Lordship can examine, but this is an order of 2012. It has attained its finality, my lord. What had happened, my lord? In the meantime, what he have done, my lord? In the meantime, 2 petitions have been filed. Thereafter, these things have not been raised, my lord. Thereafter, Lordship, he had filed writ petition number 1802 of 2014.
No, Mr. Bora, you say you have not drawn up a disciplinary proceeding again.
That record says yes, my lord.
Then how can you deny it?
Now, when he will have to challenge it within time, my lord. Lordship will see, my lord. Only in the meantime, in 2014, he came to the court
without challenging this order. And in 2017, he came before the court, filing writ petition number 7383 of 2017, where he have not stated about the impugn order. Today, he is in this writ petition, he is challenging. When the impugn order is dated 26/12/2014. And in the meantime, Lordship will see the order, my lord, page number 35, in writ petition number 7383 of 2017. Nowhere that impugn order is dated 26/12/2014. He had never said that there is an order. And he, suppressing that particular order, he has filed a writ petition. That is my preliminary objection as a maintainability of this writ petition. Because he has not come to the court with clean hands. Lordship will see the order, my lord, of 25/9/2019. Nowhere, nor in the writ petition, there is that issue has been, that impugn order of 26/12/2014 had been brought before the court. In earlier round of litigation, also he did not brought out. In 2017 also he has not brought on record, my lord. Now, in 2014 order, 26 December 2014 order, he is now challenging in 2021. And he says this order was not furnished to him. That's why in 2021, when he received the order, he is challenging them. Now, Lordship will see my affidavit in position page number 58, annexure 2, page 12. That is where I am on the point of maintainability, because he has suppressed these facts in all this earlier writ petition. Page, this is annexure 2, 58. This is the order he is challenging. My affidavit, running page number 58. Annexure 12, he is challenging. Down below, Lordship will see the petitioner's signature. He had received that particular order in 7/1/2015. He had accepted, he had received it. And from 2015, when he had received it, he had not challenged this order. And in 2017, he had suppressing this order, he had filed a writ petition. Now, in 2021, he is challenging this order. This is clear suppression of fact. In 2 rounds of earlier litigation, he has not produced this document. Now he is challenging this order. And what he have done to challenge the order, Lordship will find in page number 43 in the writ petition. After
by suppressing order.
Well, now he has suppressed this order into all along the earlier 2 writ petitions. Now to file this writ petition, he has to state that this order has not been furnished to him. Lordship will see that for page 43. Now he gives before filing this writ petition, he gives an application to the DUO that there is an order dated 26/12/2014. UP is furnishing. And then he files the writ petition. That this order has become absolute, my lord. And 2 writ petitions he has suppressed into earlier writ petition. And here also he has, it is clearly stated that
Whether there was any public motive on his part to suppress this order.
well, he should come clean before the court, my lord. When he is coming in the court of equity.
Merely because he is not produced the order, can public activated.
Lordship, he has 2 writ petitions. When you are coming to a court of equity, he should be clean. These orders have been left. Otherwise, my lord, he would not have received that. He would not have got the order dated 25/9/2019, because this fact has been suppressed. Therefore, he received that particular. He could secure that particular order, my lord, in writ petition 2017 we had filed. Otherwise, the thing would have been different.
Then if you have not complied with this order, 25.
No, 25/9, my lord. Lordship will say first paragraph, my lord. That order, my lord. This order has been filed passed based on that particular order, my lord. Because earlier order, first paragraph in 28/4/2014, there is an order based on this writ petition number 1802/2014. This order had been filed. In between, he files a writ petition suppressing all these things. And now also he is filing it without stating all these facts, that the main stand of the petitioner that this order has not been applied to him. That's why he's coming in 2021. And on the contrary, it is that he has received it on 7/1/2015.
Yes. Any other point?
That is one of the point, my lord. My lord, in this regard, I will cite two decisions of this honorable court, my lord. When you are coming in a court of equity, you should come clean, my lord. Otherwise, in the writ jurisdiction, he should come clean, my lord. My lord. Paragraph number 6 and 8, my lord. 1997, 1 GLT 68. Paragraph number 6 and 8, lordship, is absolutely clear, my lord. When you're coming in a court of equity, he should come clean, man. Whether it is a paragraph 8 is more relevant, man. May I read it, man? Apart from delay and laches on the part of the petitioner, suppression of material fact was by itself enough to misleading him from claiming any relief from the court in exercise of the jurisdiction. A candid disclosure of all material facts by the petitioner is the sentiment for the invoking writ jurisdiction. He should come clean, my lord, in all facts, so that before the court to take so that the court can adjudicate the matter in. So this has not been done by the writ petition. What's on another aspect? The
No, the same point.
delay and laches. No. Delay and laches also. This is 2016 4 GLT 59. Delay and laches. In 2014 order, he is when two writ petition he has in the meantime he has pursued. Thereafter in 2021 he cannot challenge it, my lord, because this is the delay and laches appears the suppression of fact. And another decision, my lord. Even if you're asking for a recovery of area, it cannot be beyond the period of 3 years. So this order is filed in is of 2014. Now in 2017, you cannot pursue that petition, my lord. Well, another decision, the FS Code, my lord, 2000. This is regarding delay, my lord, 2009 2 SCC 479, paragraph number 17. This means in the settled position of law, my lord, he should delay defeat himself. He should have come it within time. Then when he has suppressed the fact, my lord, that it is the equity in a court of jurisdiction, my lord, it should not be entertained. No, these are the points, my lord. Because this maintainability, I have put it in the very first maintainability because he has suppressed material fact, my lord. And suppressing material fact, he has preferred the writ petition. Not only here, my lord, other earlier two writ petitions. And he is filing in the order dated 26/12/2014. In earlier round of litigation also he has suppressed it. And now also he says he is challenging it order, suppressing the fact that he had not received it. In fact, he had received it.
Yes, Mr. Secretary, any reply?
Yes. But with regard to this letter, my lord, 26/12/2014, he said, my lord, the earlier occasion also, this honorable court was pleased to call for the record since in the affidavit, which was filed by the respondents, they have said that that the peon book was supplied, and accordingly the order was page 10, lot, page 11, man, page 57, man. That point was raised. No such signature of the petitioner. Had it been received by him at the relevant time, then matter would have been different. In the page 57, no such initial of the petitioner that he received the said order. That point, Lordship, that particular time it was raised, and accordingly, Lordship was pleased to call for the relevant record, that whether the signature is there or not. It is not there, my lord. And secondly, now they are saying suppression of fact. How there will be a suppression of fact? Well, there is this our High Court's order, judgment in 2012, passed by Honorable Justice Amitav Roy, that when both parties are known to the fact, there cannot be a suppression of fact. And here, where is the suppression of fact? When the matter of 2000, this order of 2014, I have not received it. And subsequently, when I approached, subsequently I have retired in 2017, my lord, 31st of January 2017. And accordingly, I have filed a writ petition in 2017 for pensionary benefit and others benefit, my lord. It has not been, and accordingly, matter was pending for 2 years, they did not file. When the court's order was passed, when the court's order was communicated, then I have come to know that there is an order of 14/12/2016, 26/12/2014. And accordingly, after knowing the fact, I obtained it, the said order from the office application, and I have challenged it. Had it been obtained the favorable order and executed it by suppressing the fact, matter would have been different. I have not obtained any favorable order from the office itself. When I have come to know about the order, immediately I have come before this honorable court challenging the writ petition, and there is only 5 or 6 years delay. 5 years.
What is that?
Lordship. This 2012, my lord, that part I will supplement. I have, but other decision I will rely on, my lord. It will help in my case, my lord. It will go. First, I will rely regarding after the reinstatement and back wages, my lord. The last para 7, my lord. I'll not take much time, my lord. Only the relevant portion, para 7, my lord. 7 and 8. The point that remains to be considered in whether the appellant is entitled to payment for full wages between 1979 and 87. The appellant was placed under suspension on 23/10/1979 and his suspension was revoked on 21/10/1987. An interesting development took place during the iteration by which the disciplinary proceedings were dropped on 21/3/1983. It is clear from the record that the appellant was the one who was seeking postponement of the departmental inquiry in view of the pendency of the criminal case. The order of suspension was in contemplation of disciplinary proceedings. By virtue of the disciplinary proceedings being dropped, the appellant becomes entitled to claim full salary for the period from the date of his suspension till the date of closure of the departmental inquiry. Thereafter, the respondents took 4 years to reinstate him by revoking his suspension. The order of suspension dated so came to end on 21/3/1983, which is the date on which disciplinary proceedings were dropped. The appellant ought to have been reinstated immediately thereafter unless a fresh order was passed, placing him under suspension during the pendency of the criminal trial, which did not happen. Ultimately, the appellant was reinstated by an order dated 21/10/1987 by revocation of the order of suspension. Though technically the learned additional solicitor is right in submitting that the impugned judgment does not even refer to the IA, we are not inclined to remit the matter to the High Court at this stage for fresh consideration of the point. We hold that the appellant is entitled to full wages from 23/10/1979 to 21/10/1987 after adjustment of the amounts already paid towards subsistence allowance. For the reasons mentioned above, we approve the judgment of the High Court by holding that the appellant shall be entitled to back wages only for the date of acquittal on 31/8/2001 till date for his reinstatement. Further, reinstatement on so. Further, the appellant shall be entitled to full salary from 23/10/1979 to 21/10/1987. Full back wage salary was paid after reinstatement. Now, second, this 2008 1 GLT. Second, there is itself, my lord. Lordship has got it.
Yes.
This is our High Court's division bench, Jugamaya Saika. Back wages denial on ground of no work, no pay, which this question is arising, Principles of no work, no pay cannot be applied mechanically, nor can it be automatic. Appellants not being allowed to work by the institute, principle of no work, no pay cannot be made applicable. Lordship will find para 9 and 10, my lord. This 9 and 10 probably I should not read, my lord.
Yes.
The next question which require our concern is whether the learned single judge was right in refusing to pass an order for back wages by applying the principle of no work, no pay. Such principle cannot be applied mechanically, although it is true that the payment of back wages in all cases cannot be automatic. It depends on the facts of each case. In the incident case, it is evident that the writ petitioner insisted that they be allowed to work up to the age of 62 years in view of the resolution adopted by the Board of Governors on so, which was approved by the state government so, but it is the NIT who refused the petitioner to perform their duties up to 62 years. We do not find any fault on the part of the writ petitioner in not attending their duties, and rather they are not allowed to perform their duties by the institute. That being the position, the principle of no work, no pay cannot be made applicable in the present case. In this connection, so. This is the case 9 and 10. It has been considered the case of the petitioner. Whole amount, this no work, no pay will not be applicable. Page 9 and 10. Next, this substantial justice deserve to be preferred, this 2015 for and even for delay, para 18,
Okay,
Lordship. Para 18, Lordship. And lastly, Lordship, only I'll show the para, my lord. 2020 10 SCC 706, the para 8 to 11, my lord. Basically 9 and 10, 9, 10, 11, my lord.
Okay.
My lord, regarding delay and laches, if necessary, not necessary.
The para is file is available.
My lordship will need to go to this file because it's a fact, my lord, 53, my lord. If you are going to 53, that DP has not gone, there is no DP. And that is the fact, my lord. The file is here, my lord, but that record is not along with the note sheet, my lord. That is there. And it's a fact, my lord, that DP has not been conducted.
The fact that the beyond content
Peon book, my lord, no, peon book, my lord. I am annexed the peon book, but it's absolutely clear, my lord. He has signed it. That lordship will examine, my lord. Page number 58. His own signature is it. Now he cannot shift it to the peon book, my lord. Peon book we have shifted. He may not receive it, my lord. He is denied it, my lord. But the fact is that his signature is there. Order dated 26 December 2014. He was supplied to him on 7/1/2015. His own signature is there.
No, we have,
that is the contention, my lord.
Already we have told before the honorable submitted, my lord. On that day we have been signed, and I have been told I have been allowed to sign, and I have been told that your order will be dispatched through postal.
He knew it on that
and
particular
that
day.
part, had it been received in the postal, they send it through postal, and if it is received to us, they have not sent it.
It's admitted statement. He has received it.
Lordship, another this last order, this it will be helpful, my lord. This 2020 2 SEC 569 into. This is para 12, my lord.
Okay, you mark the
Yeah.
paragraph.
Lord.
Or that is
Obliged.
I'm obliged, Lord.
may I please
Before submitting, I have a prayer matter, so time may be allowed to file our affidavit. As we have not received any, we have not received any. So
This is a matter pending right from the year 2022, my lord. I have objection, my lord, regarding this.
This
There
is
my
25th.
affidavit.
This
Since the
petition
matter,
is filed in the year
my lord,
2025.
there is a private respondent. She is the headmistress of the school, my lord. She has clarified everything, my lord, in detail, my lord, by filing an affidavit in opposition, my lord. Therefore, my lord, my humble submission before this honorable court is that the affidavit from the department may not be necessary. If your lordship kindly goes through the, my lord, affidavit in opposition filed by the headmistress as well as the contention by the petitioner, I mean, him, herself. The entire petition is, my lord, based on, my lord, only 2 documents. Yes, already, my last occasion also, my lord.
We have not received any. We have not received any. So we cannot file a affidavit. Yes, ma'am.
Lordship will kindly fix a date then.
Yes. And
that's not that number. 124.
One, 2, and 4, my lord. Only 1 and 2, my lord.
Pardon?
Because I cannot appear on behalf of Mission Direct. Mission 4. SS.
1 and 2.
Yes, my lord. 1 and 2, my lord.
Or 4.
Yes.
Which for 3?
Deputy Commissioner. Video is not be recorded.
That is part. That is 1 time 5. Yes.
My lord, the date may kindly be given, my lord, on 27, my lord, if possible. Deputy.
It be pleases your lordship. Your lordship, today we are going to file our affidavit, your lordship. Your lordship. Yes, your lordship. Kindly matter me list after 1 week, your lordship, to bring it on the records.
Part.
HL, my lord.
Secondary.
Secondary, my lord. My lord, date may be quick, my lord.
Deeply obliged.
Correct, His Lordship. Last August, your lordship directed the finance to obtain the up-to-date instruction regarding the status of the case.
Yes, your lordship, we have conquered the proposal, your lordship, on the 4th of July itself, your lordship. Yes, your lordship. Now it's the education department. Yes.
After? After a week.
So the date may be fixed, otherwise, unless it
Day pass or
1 and 2, your lordship.
or 1 and 5.
1 and 2 more.
For it's
1 and 2.
So convert it to the government of the part. Uh, finance part. Part. Approve the for regularization or is something that 1 week time in respect of the process of their after 1 week.
should date may be fixed.
Make it
Lordship, my senior is on like can you pass over the time being.
which is it
Senior वो भी भैया.
the grade 3 employee, my lord, only because of 1,80,000, my lord, was given more to him, my lord. He has not got his, my lord, pensionment retirement benefit already calculated, and this information has been given by the authority, my lord. Kindly peruse your lordship. Page 23, my lord. The Rofik Masi's case fully covered case, my lord. Rofik Masi, one of the my lord, case judgment decided, grade 3, grade 4 employee, my lord. It's number 23, my lord. From February 2020, my lord, in compliance of the, it was submitted by inspector of the school, my lord, to the director, my lord. In compliance of the with the contents as brought out in your letter under reference, I have the honor to apprise your honor that Sri Bhairav Chandra Das, retired senior assistant, proceeded retirement on 29/2/2020, and subsequently the then inspector of the school GDC Gwalpara has initiated all sorts of activity in regards with his family pension, and later on, as per your instruction on the body of your aforesaid letter, the personnel file, the other relevant records are verified along with his service book, and it is learned that an amount of rupees 15,240 rupees has been fixed 1/1/2011, but not 1/1/11. As stated in your letter, copy of the service book page enclosed noted that the then inspector of the school, Abdul Jalil AES, now retired, put his signature against the fixation, and then accountant pension cell Anwar Hussain, retired, of Gwalpara, made the entry of the fixation in the service book, and his initial is also seen beneath the seal of the inspector of the school of GDC Gwalpara. The undersigned has gone through all the papers, and identification has now come to the light. As per my knowledge, believe then the inspector of the school and the then accountant, as noted above, may perhaps be fixed and recorded wrongly in his service book. The undersigned has done no any wrong regards this with the pension matter of Sri Bhairav Chandra Das, retired. So, my lord, as per this judgment, also I have annexed here, my lord, and the notification, my lord, he is entitled, my lord, because the amount also I have also given here. This, my lord, page 23A.
Is the date of actual date of retirement was?
He retired, my lord, only because of great some amount has given more, my lord. Wrongly calculated his grade pay scale, my lord. That was the mistake, my lord. Page, my lord, 23A. Calculation sheet of pay revision area 1/1/11 to, my lord, 28/2020, my lord. The amount is, my lord, 2,81,870. That was stated to be, my lord, but that was not his mistake, my lord. And the Rofik Masi's judgment, my lord, it says that my grade 3, grade 4 employee, if any mistake is done, my lord, one judgment, my lord, I have annexed here, page 26, my lord. Annexion 9. Just I am reading the present term, my lord. If excess amount was not paid on account of any misrepresentation or fraud of employee,
Whether you have received an notice from them
Lordship,
or recovery of the said.
that's why, my lord, only because of that reason, my lord, they have not released the, my lord, family his retirement benefit, pensionary benefit, my lord.
Where is that letter?
That letter, my lord, matter has been kept pending, my lord. That's why one after another represent I have to submit. Page last annexure, my lord, I want to place, my lord, annexure 8, page 25. This was my last representation regarding waiving of excess amount.
Whether they have communicated you that you have drawn excess amount.
Yes, my lord.
By which letter?
Oh, yes. That letter, my lord. Page annexure 1, page 17. Accountant calculated it after his retirement. Subsequently, I submitted representation annexure 2, page 18, saying that, okay, my lord, waiving that, my lord, mistake, my lord, and page 22, annexure 5 also, my lord. It was issued by the joint director, my lord.
You have not been receiving pension till
No, my lord. Of February 29 is my lord waiting, my lord. 2020. And only because of this, my lord, 2,81,000 has been given. And one notification also published by the government, I have annexed here, that those are the grade 3 and grade 4 employee. It cannot be recovered, my lord, after retirement or before retirement, 5 years, my lord. If mistake anything, not from my part, my lord. That is also followed the Rofi Pasi judgment, page 32, annexure 10.
30.
32. Pursuant to decision of the cabinet meeting held on 20/10/21, paragraph 9 of the OM dated so amended as follows.
Yes, who is appearing for the
I am appearing, Your Lordship. Your Lordship, in this case, Your Lordship, instruction is awaited, Your Lordship.
what
And
the-
on here only mentioned that due to wrong. Due to wrong record of his pay, Your Lordship, in the service book, and Your Lordship thereby and thereafter, Your Lordship, a representation dated 29 March 22 received from the petitioner, which was also forwarded to the Commissioner and Secretary to Government of Assam Finance Department as per the office letter by so and so dated and closed, Your Lordship. And Your Lordship, nothing has been clear here in this instruction, Your Lordship. So we have to obtain another one, Your Lordship. Nothing has been cleared.
affidavit is required because
Yes, Your Lordship.
in view of the decision of Supreme Court in the case of Robert Masti,
Rafiq Mashik is there. So, Your Lordship, kindly grant us 3 weeks time, Your Lordship, to file our affidavit.
the person was
Your Lordship,
decided 1,000.
by this instruction, we could not able to file our affidavit, Your Lordship. So,
Whether your affidavit is necessary here.
covered
In
হলেও
view of the decision of Supreme Court,
Your Lordship, 110 may take from our side, Your Lordship.
have you gone through the decision of Robert Masti?
Yes, Your
We have gone through. And have you gone through the notification of your department, finance department, dated 27th of February 2022? Annexure 10. Is it available with you?
I may allow to send it, Your Lordship. No, more instruction to herit it.
Madam, you do one thing. You please go through the decision of Robert Masti and also go through this annexure 10. There are 5 points. And you argue the case day after tomorrow. Your affidavit or instruction is not required. This is well settled for part, sir, is the and it he does certain candidate part. This is the matter. This is the matter. So as enable does go to the next number 10. The decision also to the decision. Need to consider further from by in CA number 157 of 4. placed accordingly.
Okay. My lord, on the last occasion, notice was issued. This is a POCSO matter, my lord. But as per office note dated 14/8/25, service report is awaited, and my lord, trial court record is also not received.
My lord, report not received, my lord. My lord, give us a short date, my lord. In the meanwhile, we will take a report, my lord, whether service is made or not, my lord.
Accused and the POCSO, learned that office dated 14/25, the third court of the number 2, and the trial record has nothing. Accordingly, it is provided that the POCSO that furnished the service for on
Short date, my lord. 22nd, my lord. 22nd, my lord.
Register of certain reminder the learned trial court and record is according.
Okay, okay. Can it be on 26, my
My lord, 26.
Obliged.
Deeply obliged.
Lordship, wait, please. Lordship, petitioner worked as senior professor of Cotton University as well as pro vice chancellor, your Lordship. Subsequently, Lordship, he resigned that post. Lordship may kindly have a look at the order dated 28/7/2025, wherein the counsels appearing for the other side took time to obtain instruction. Now, my present claim is as regards the payment of salary for the period, your Lordship, 24th of July, till December 2024 to 24th of July 2025.
Yes, sir. Higher.
My lord. My lord, I appear for the Cotton University. My lord, the system in Cotton University is such, my lord, as per the Act. The earlier teachers of Cotton College, my lord, they are government employees. They draw their salaries from the state estate. My lord. It's only the employees of the erstwhile Cotton College State University and Cotton University, my lord, who get their salaries from Cotton University, from the university funds. My lord, now this payment of salary is for the government because they get their salaries from the government. Their entire service benefits are on the government. Now, my lord, in this case, what had happened, my lord, the petitioner was to retire on attaining the age of 60 years on 31st of March 2024. There was an extension of his service by the government, my lord, which was issued in July 2024, but was withdrawn on 11th of November 2024. The stay order or the status quo order, my lord, was passed on 13th of November 2024, 2 days after the withdrawal. So whether he would be entitled for salary after 11th of November.
I'll make a submission.
That is an issue to be decided.
Yes.
In the meantime, on the last date, my lord, there was an there was an information that because the petitioner has been appointed as the Vice Chancellor of Kolkata University, he has resigned. My lord, he had submitted the resignation to the registrar of the university, and the registrar had sent the letter to the Secretary of the Education Department. Thereafter, whether it has been accepted or not, but my humble, my lord, take on this is, my lord, since the withdrawal is already there is nothing to resign. Since the government says that his services had already been withdrawn on 11th of November, the extension. So he was not in service from 12th of November 2024. So there is no question of it.
Lordship, order of withdrawal. Lordship may kindly have a look at para 9 of my writ petition, which was filed, which is WPC 5934. There are 2 writ petitions, my lord.
With the higher part.
Okay.
Lordship. Again, I am handicapped, Lordship. In this, both the case, Das is appearing, Lordship. Himant Das as Lordship. If it is there, but I present instruction, what happened, I could not.
Madam, can I take it up Thursday?
Lordship, that will be
Lordship. Thursday is Lordship, Ajikita. Well,
deeply obliged.
So, Subha,
Yes, ma'am.
again, which order you have deferred the FAO?
My lord, last page, my lord. Annexure L, my lord, consider. Annexure L, my lord.
Annexure?
L, page 111. My lord, in this case, my lord, someone was a suit, my lord, title suit, case number 17, title suit number 17 will 25. Someone was a suit in this, my lord.
That's right, but you are not deferring this FAO against the order passed in the title.
No, my lord, yes, my lord, yes. My lord, I have challenged, my lord, the order dated, my lord, 5/7, that is also 5/7, passed in miscase,
Yes.
whereby, my lord, my
Yes, where is that order?
My lord,
Where is that order?
that is order, my lord, page, last page, my lord, 1 to 6, my lord.
126.
Yes.
126. How do you tell me whether notice has been issued by this order?
My lord, nothing is, there is
Nothing.
regarding, yes, my lord. My lord, in that case, I prayed, my lord, for injunction, ex parte injunction, my lord, but without considering that, my lord, prayer, this was issued.
No, no. Going by this order, can it be said that notice was issued to the other side?
No, my lord. But in title suit, my lord, in title suit, my lord.
Forget about title. You are not challenging the order passed in the title.
Yes.
So, in fact, notice was issued by order dated 1/8/25.
My lord, in misdemeanor case number.
Yes.
That is there.
Yes.
Petitioner side is directed to take.
Yes.
But my lord, this is first order, my lord.
This order have been the impugn order.
My lord, but this case was filed, my lord, before date, my lord. My lord,
But
this was filed on.
That the trial court has not considered
My
your
prayer, my
exemption
lord.
petition.
Yes, my lord. Against which, my lord, I approach this on court.
Notice was issued on 1/8/2025. So this should have been the impugn order.
My lord, but my lord, kindly see page 1 to 6, my lord. This is a petition under order 39, rule 1 and 2, read with section 151 of the CPC, filed by so and so for temporary injunction against the opposite party, number 1. It is checked and registered as Mrs. case number 2, fixing 1/8/20.
No notice was.
Yes, my lord. No.
Then should have been notice was by order dated 1/8/2025. The
Yes.
trial court has considered your prayer.
Yes.
So this should have been the impugn order 1/8.
But my lord, after filing the case, my lord, FAO on 24/7/25,
This has been issued on last occasion, my lord, on 118, my lord. 181.
What to
Things on the
this
first
by
day.
issue order?
Actually, my lord,
Whether you withdraw this petition and challenge this order 1/8/2025.
my lord, since at the time of filing of this case, FAU, my lord, filed first appeal, that order was not there. This order was passed, my lord. Against, my lord, without considering my prayer, my lord. That's why it was, my lord, challenged.
So, from this order, it can be assumed that the trial has the earlier order cannot be terminated. You think over Wednesday or one or application.
My lord, in the meantime, I may be allowed to, my lord, to, my lord, bring this report, bring the record of this one order dated 1/8, challenging the date order. 1/8/25.
Want to challenge the same kind of opportunities have you?
On the day,
Pardon?
on the day, my lord, the day fixed, my lord.
You will take a call.
Problem.
In item 37, I have instructions not to press this matter. Lord.
Item number
37. Lord.
37. Sir, MP Sharma ordered something of that. He has the instruction of press.
Just 1 minute.
Both of it.
No,
No.
next petition is present by, in this case, my lord, you are representing response number 3, the PSC, my lord. We have filed an affidavit. Next case, I don't know, my lord.
My lord, there is an order.
Okay, but let me close this. We close this application. Lord, in view of the statement made by Sir Sharma ordered, petitioner is WPC number 38/2007 closed.
Lordship, it would be
3833 নহয়.
it would be Lordship
3780. 3780 is closed, my lord.
But
So that our presence should be recorded, my lord. In earlier case.
First one.
First one, because it is required. Why is it required? I will explain, my lord.
3832
No, my lord, yes.
Okay, all right. We will record your presence.
Response number 3, my lord.
TJ Mondo, counsel assisted by
P. Sharma,
Garden Council, APS.
My lord.
So, what? One. Yes.
My lord, there is an order that the APSC wanted to file affidavit in WPC 3833. But I have not received any affidavit.
That is the reason, my lord. That's why I am submitting. This order, same challenge made, my lord, in this case, my lord. We file a affidavit in one case, that first case. Now it has been withdrawn. So that it is been known, I have to file a, my lord, again, my lord, I have to file in this case, my lord. Otherwise, the same affidavit will cover both the cases.
Okay.
Sir, now, my lord, if your lordship permit me, within week or 2 week, I'll file.
Okay.
That's why, my lord, I'm submitting.
Okay. Or the
SS Goswami. SS Goswami.
SS the or APS.
My lord. Please, Mama.
The learned counsel for the petition so the PSC has filed its affidavit that he has not received a copy of the also submitted according to the
That is the So I have to file a separate matter.
By this court. Right, so, one week time, file evidence.
So let it be 2 weeks, my lord. It will be difficult 1 week. Because
Is already there.
no. Again, I have to send it for vetting. That will be time. I think, well, yes, all right. 2 weeks, my 10 days.
10 days, like, here.
No, Develop.
2017 method.
Yes,
just
my lord.
fix it.
Actually, selection. There was a selection of the my lord. Already, my lord. Probably the other one lost interest. Now, actually, my lord, the first one which was withdrawn, he was second. The private respondent was first. He is third. So, my lord, now second which one, my lord, he is already out of frame, my lord. The third one is my lord. That is why, my lord, because of his withdrawal, my lord, probably there is a life in this case, my lord. Develop.
Lord, kindly consider order dated 11/8 of 2000 and previous order 6/8 2000.
So 60.
Yes, Lordship. Here, Lordship, I have received my instruction. Initially, we have submitted the pension proposal to the pension department. They have raised some queries. Then again, we have resubmitted. No, this. No. Yes, here, Lordship, we have already released an amount of 22,74,450 rupees, Lordship, and he has. It was released by bill number so and so dated 38/24 in the month of August 2024 itself. 22 lakhs has already been released, Lordship. And so far as rest of for last and for the month of March 23 to February 24 losses, the bill has been submitted by the school only on this 12/8/2025. Only this month 12 losses the school office submitted the bill. Now it has been processed. It's under process loss. This is my instruction.
You have received that amount?
Yeah, 22 lakhs he has already received.
That person received. Now my current.
Only the current salary, the proposal from the school has received only on this 12th of August losses. Now the inspector, the IS is processing the.
How much time?
It will be go to the finance. It will take some time, Lordship. It is after 4 weeks, Lordship. Yes. But 22 lakhs has already been received, Lordship.
It's not.
In the second para, Lordship, the 22 lakhs 74,000 is there, and in the third para, the bill number was there, and the fourth para, Lordship, that area of for March 23 to February 24 has been received from the school authority only on 12/8/2025.
Yes, I am receiving, but March 2023 to March 2000 April 24.
That area, that 1 year area
1 year
salary,
area.
that he is yet to get, Lordship. And earlier area salary that he has already received. Oblige, your lord.
Date, my lord, the date.
It will take some time. Let it will come. He has already received a substantial amount. Only that 1 year it takes some time because it will go to finance. It will. It will come. We have already complied a substantial part loss. So only that part.
Because my lord, contempt matter, we take. Oblige, deeply.
That I should give you enough 40 budget.
It was regarding provincialization of service of the petitioner. Matter was pending consideration of the service, my lord. Hearing has been conducted.
My lord. And my lord, secretary of this, secretary has passed this order, my lord, on 16/8/2025, my lord.
I appeared, my lord, for the 6th time, my lord. I had to come and attend the hearing.
My lord, with your observation that a petitioner is the senior most, my lord, and therefore D is directed to, my lord, proceed.
Now the matter will be passed to the
My lord. SLC, my lord, may take a, my lord, take this matter after 1 week, my lord. In the meantime, I will take, my lord, from the direct. As by the secretary, my lord.
Maybe kept as part of record, my lord. This one. Maybe kept part of record. A copy may kindly be given.
My lord, I will find it.
Oblige.
In this matter, petitioner was died in harness on 18/12/2016, and my lord, they have submitted an application on 25/5/2017. But my lord, here, personnel B department issued an office memorandum on 18/9/2024 directing all the departments not to entertain any cases of compassionate ground appointments, including the cases to not known prior to 31/3/2017. As per this office memorandum, the cases of employees who die or died in harness after 31/3/2017 have been taken care by way of compassionate family pension scheme in lieu of compassionate appointment by office memorandum number FEG 28/2017/26. And in that speaking order, my lord, here it is finding that after careful consideration of the above facts, it has been decided that the claim of the petitioner for appointment on the compassionate ground cannot be considered at this stage, as the personnel B department by their office memorandum number so and so dated 18/9/2024 issued direction not to entertain any cases of appointment under the compassionate ground. This is my instruction.
This officer may be direct. My humble request, this officer may be direct to appear before the court, Lord. That's because the order was to place the case of the petitioner before the next SLC, Lord. State level meeting was held on 18/8/23. Her case was not placed before the state level committee. shows he has made the serious contempt, Lordship. Even now he has made, without any appeal or review of this order of this court, he has made some unsustainable statement before the court, Lord.
Here, my lord,
So
they have
when
placed
there
the
is an order in a contempt proceeding, where there is an order, he has to comply the order or may file appeal, review that. That's different thing, Lord. When there is an order, he cannot place such thing before the court, Lord.
my lord, here, as per order, they have placed the matter before the state level scrutiny committee, my lord. Here it is in paragraph, in pursuance to Honorable High Court order, said order, the case of the petitioner was again placed in the
When it was passed.
held on 18/8/2023. And before that, it was also placed on 4/1/2000. Yes, 18/8/2020.
Order was passed by this court on 28/4/2020. How can you place the matter for passing the order of
According to the estimate of the 18. So I need some time to clarify all these things, my lord, regarding that. But no, but it was placed.
Direction
not been complied with by the court. Deed of dated 28/2020, where there is direction for passing the matter of the asset. And as the matter the order being passed by the court. What is it?
Here, my lord, it is stated that as per recommendation, the Department of School Education took necessary steps.
You apprise this court what happened after passing of the order. Yet, Lord, sir, and Lord, uh, it's the matter not Friday, but from a update Friday.
problem.
May I please lordship? I'm on behalf of Mr. R. Korim, my lord. He's out of station. This honorable court directed the
Lordship, in this matter, I was directed by the Honorable Court on the last occasion to file affidavit bringing the happenings into the record, the instructions that has been obtained by me, Your Lordship. Accordingly, I have filed it on Saturday. I have filed bring the documents into record. Lordship, further for the expediting of the contempt petition, Your Lordship, but it transpires that on 17/7/2025. 17/7/2025. Your Lordship can peruse it. One communication was sent from the Director of Pension to the Inspector of School, Your Lordship, whereby it was asked the original service book along with the proforma, filled in proforma was sent along with, Your Lordship. So the Inspector of School, Your Lordship, if they furnishes the same to the Director of Pension, that will expedite the process.
Yes, we have already.
And if they have sent it, let me have that particular copy and I'll accordingly communicate to the.
And send it back to the director. Earlier, we have sent a proposal. They have made some queries, lordships, regarding filing up of some performance. That we have made it and we have sent it on 8th of August, lordship.
After again,
After filling up the application, lordship. To the director of pension.
8th of August.
Everything has been sent to the pension department. All the original service.
After 8 tarike? But my communication is of 17/7. Thereafter.
77. right?
July. ঠিক আছে, ঠিক। So let me have a copy of that and I shall communicate with them and update the instruction on the next.
Now, pension department director have to put the proper for TPO order. That is the meeting.
T. Sheikh, my lord, on behalf of Mr. R. Korim. Mr. R. Korim, my lord. My lord.
I'm for respondent 3. Respondent number 3.
No,
Two, your lordship. Two.
I'm for 1, 3, lordship, 1 and 3.
I'm for 2. Thank you.
This is in reference to the letter 77.
I'm for lordship, let it be after 2 weeks. My one, that is affidavit, your lord. There is affidavit. A part of that affidavit, it is an excerpt as per the instruction of this honorable. Oblige, your lordship.
May I pray for a fixed date, my lord? Petitioner is suffering, my lord. Bless my.
Lordship, some negotiation is going on amongst the parties. So 3 weeks time may be given.
Ongoing negotiation.
Three.
Keep your place.
May I pray, your lordship, restoration petition, lordship. I was ill on that day. I could not even, medical certificate has been next page 21. And order is this for non-prosecution is at page 31. Just one time I was. Lordship,
Let notice go.
no, already notice is served. Already notice is served before filing.
When?
What? Okay.
Yes. No. দিয়েই তো ফাইল করেছে filed on 14/7 within 30 days.
This miscellaneous application is filed, Your Lordship, stating that the prosecution has matter, Your Lordship, restoration or restoration. So earlier, Your Lordship, in repetition also, it has already, Your Lordship, the matter has already disposed of, Your Lordship. So this misapplication has filed for restoration that earlier writ petition 1166/2023, which was already passed for, Your Lordship, dismissed for default, dated on 13/6/2025.
After serving notice only, restoration petition is.
There are Rickman as the opposite party. Notice the court.
What is the document that on that day?
Lordship, kindly have a look at page 21 and 22. 21 and 22, annexure 1.
Yes.
No, Your Lord.
Hard, sir.
Islam.
Hard.
Yes, that's the date now.
And
Treasury.
the order of
1, 3, and 5.
of was by but also that not taking present or present that they have support right order dated 30 right the double for double not the order
1, 3, and 5. Look at the writ petition to DD Bohar. Then,
that part of this that or fight the was suffering diarrhea and abdominal pain.
Nurse Council should be here, Your Lordship.
Fight. The part and of number of the order of the
In the last week of September, Lord. Yeah.
That's practical. Receive
Lordship, deeply obliged.
अपना नंबर तो दियो
May I plead your lordship? Lordship, service in respect of respondent number 1 and 2 is awaited, lordship. I want to take justice service upon respondent number 1 and 2.
who is completed.
Oh, pardon me.
Respondent number 2 completed.
Respondent number 3 completed. Respondent number 1 and 2 is awaited,
You
lordship.
want to
Editor receive, lordship. It read. Huh? Secretary. Yes. Copy नहीं लिखी। वो अपना रेस्पोंडेंट नंबर 7 ना सेक्रेटरी नारायण सेक्रेटरी
Seva, Lordship, there is a difference in
hard next
R का copy
or calculate or petition. That data that it occurred it's a fact that one heard of it. They don't that affects what by the get after fact or after
1 week
after
Lordship. Here I may be allowed to take private.
or Oracle
Elementary Education Department.
or or take respective of the
Yes, 6, my lord. 6, my lord.
here is a potential of stability register ATM or
I may be
the number letter of Mr. David learned on a learned study of the number learned and its summit step. This may be directed